Yes, sir. It's a public interest litigation. Opposite party having no right, title, and interest unauthorizedly occupied the government land, my lord. So that the village is something
Minor daughter of the petitioner, my lord.
Pass on the slips.
Tomorrow, my lord.
Pass on the slips. Pass on.
Regarding tender matter, my lord, they are without
Pass on the slips.
tomorrow, man. They are going to another tender matter without opening a cancel the tender matter
just
without
give-
any reason.
It will appear, don't worry.
Yes, tomorrow, man.
We'll try to take up. Yesterday, there was two big matters which consumed a lot of time.
May I pattern to mention, my lord, today's supplemental list item 110, my lord. The matter regarding the public interest litigation, my lord. The collector Gocher, my lord, permitted the operating the stone quarry in favor of the opposite party number 9, my lord.
What do
Opposite
you
party
want,
number
sir?
9.
What do you want, sir?
He wants lordship can be taken up today, my lord. With the
We
blasting
will definitely try. We will definitely try to reach. Don't worry.
Maybe not reach, my lord.
Let us see.
Lordship, there are villagers dwelling house already.
If we cannot reach that at the time of rising, just remind us.
Yes, my lord.
My lord, I am on. Want to displease your lordship.
No, please, this is all pleasant to hear all of you. What you are saying? Speak.
After repeated memos, after repeated court slips also, this matter has not been listed.
I was not there, sir, September.
Miller,
So,
your lordship
pass
has
on the
also
slip.
directed Miller. Twice. Kindly.
Oh, this is the memo you call it. We call it a slip. We call it a mentioning slip. So
Once
just give the memo, ma'am,
lordship directs, it becomes a court slip. Oh, that's it.
please.
I may be pardoned.
Pass on, madam. Pass on the memo.
My lords,
Petitioner will vacate it, like they will be forced to evict it today or essentially.
We can't take up without the matter being listed. Now CIS system will not accept unless the matter is listed. So you let it appear tomorrow, let us see. And inform the other side. Give, please. Please give all the memo.
If it will be listed tomorrow, I will withdraw it.
Let us, you withdraw it. Oh, welcome. For withdrawal.
I may be pardoned to make mention, my lord. Today's list item number 33, my lord. May please be taken off. Only because it's a very serious matter. It's a matter relates to Sisu Hall, my lord.
Don't worry, sir. We are also very serious.
My lord,
So we'll take up. Don't worry.
your lordship, interference, this matter has already been listed and the matter is also in the board.
Let us.
Man,
We'll take up. We'll try to take up.
Only small sums I want to make. These matters have been listed today's list as this honorable court desires to know from the additional commissioner CMC about the present status of the drainage work,
We
my lord.
appreciate, sir. Let the other side be there. We will ask him to.
If possible today,
So we are just wait, sir.
my lord.
Just
Lordship
we'll try.
item 86, today's list, Lordship. Lordship, this is a case pertaining to the formulation of policy on Chilica, Lordship. Last time
Formulation of policy.
on Chilica, Lordship. There is a direction.
Fishery right.
Lordship.
Fishery right.
Yes, Lordship. So this matter can be taken up. Item 86.
Let us see, sir. Let us see.
This case urgency is respondent may file contempt against appellants, my lord.
Oh. Give contempt.
Pardon to mention, lordship. Item number 101 kindly be taken today. There is a urgency, lordship.
Sir, we'll try. Definitely
try.
We'll try. We are pressing hard to do reach all the matters.
To mention
I am on virtual mode.
Challenging the dismissal of an Anganwadi worker. They have taken out fresh advertisement, if not taken out.
And pass on the memo. It will appear. We said every memo should be given to us. We'll take care of that. Don't worry.
The press admission covered by your lordship's order. I am giving the
We may
order.
change our mind.
No, please.
We may have committed wrong at that point of time. We may change.
Only interim order, madam. Kindly taken up tomorrow covered.
Here.
I am giving the order.
Pass on the.
Item 52, I want rejoinder. Item
So let it reach, sir. You prepare your rejoinder. Come ready. We'll accept it. Don't worry. Don't worry.
Pardon, that item number 24, supplemental list, kindly taken up to next week, madam.
Why, sir?
That's some.
Everybody wants their matter to be heard, and you are asking for an adjournment. What is this? Let us see. Let it be called. At the time of call, remind us.
Mr. Das, it is a specific urgent matter.
I have filed the documents.
All right, all right.
Today's
Yes,
some
at the time
difficulty.
of call, we'll see.
Will definitely just.
Today is some difficulty.
Lords, I'm on
Are you in
virtual
hurry?
mode.
No, I'll say. I have
So
some
just mention when it is called. Don't worry.
medical
Consider.
difficulties.
Lords, I am on virtual mode. May we permit to make a submission?
Sir, how can I prevent you, sir, from making submission?
Well, there's an execution case pending under Order 45, Rule 15. Execution of the orders of the Honorable Supreme Court. It's a decree. Now, this is a 97 matter. This needs to be specially assigned. This was last heard by Justice B.N. Rath, as he then was. So
Sir, give that number at the chat box. In the chat box, we will definitely see to it.
I am grateful. I am grateful.
It's called.
I may pardon to make a mention, Your Lordship, item 41. I understand you also just said to my learned senior that I just pray that it be taken up next Thursday. I've had a word with my learned.
You are here. Do you have any problem today? So just remind us when it is called.
Your Lordship, I may be permitted to.
Item 41.
Yes, admission matter.
Please pass on the memo.
Well, as in item 41, well, as my learned friend was mentioning the matter.
No. We said at the time of call. Don't
Yes,
worry.
but if the matter is taken up today, well, then I'm opposing the adjournment. We'll argue the matter.
Yes. You have to convince her.
She just confirmed who want to take it up
Because
next
if
week.
the matter reaches, the only request for adjournment was if the matter doesn't reach. If it reaches the tender matter, Melody,
That was a conditional one.
if it reaches today, Melody, I would definitely
Yes,
press.
we appreciate, madam. It was a conditional consent.
I'm so grateful. I'm so grateful.
Yes, call the list.
Supplemental list, fresh submission, item number 1.
Okay, please, Your Lordship. Thus, the Odisha Public Service Commission issued an advertisement for the post of Assistant Professor Teacher Education.
Yes.
The advertisement is at page 19 of the brief.
Yes. Yes, what it says.
Because in this advertisement, serial number 1, there is a vacancy position at paragraph 2, where is the table.
Yes. Teacher education.
Teacher education, and this is the discipline of educational studies.
Correct.
This is what the discipline.
Total vacancies is 113.
113. Well, it's PWD vacancies. These are physically disabled persons.
Correct. There is nothing.
There is 4% of 385 posts. So, in respect of the total advertisement, there is 4%. So, well, it's for the present discipline, 4% of 113, that comes to 4 posts. Therefore, 4 posts were reserved for physically disabled persons. Then, well, the method of selection is at page 22.
No, the total post was a 15 out of 385.
Out of 385 is the total of all 12 disciplines. In the present discipline, there are a total of 113 vacancies.
So you wanted this percentage, 4% to be calculated on the number of vacancies of each category.
But that is not in dispute in the present case.
Okay.
Admittedly, my lords, 4 posts were reserved for PWD candidates in this discipline.
Correct.
Now, the method of selection is at page 22.
Examination.
Conduct of examination, stroke method of selection.
Merit to be judged by performance in the interview.
Interview, yes, my lords.
Yes.
And your lordship will see clause D also. On the basis of result of interview, the commission shall prepare a subject-wise merit list of successful candidates arranged in order of merit equal to the number of posts to be filled up and furnish the same to the government.
Right.
This is what the rule also says. Because what this advertisement did not say was that the OPSC has also fixed a minimum qualifying mark of 50% in the interview.
How can that be done? How can that be done? First thing is the only criteria of an interview, you know, the Supreme Court has in some judgments have deprecated it. That when it is on the merit, then the merit has to be judged by some other means as well. An interview will be one of the integral part of it.
Well, it's because the university, in respect of recruitment to higher education institutions, the broader field is governed by the UGC regulations. And the UGC regulations prescribe interview as the only method of selection.
Then that is binding.
That is binding. And in the present case, we have a rule framed under the proviso to Article 309. That rule is at page 223.
So what do you say? The 50% should be the criteria or should not be the criteria?
Well, we have fixed a cutoff. We have fixed a minimum qualifying mark of 50%. The learned single judge holds that since neither the advertisement nor the rules explicitly provide for minimum qualifying marks, the fixation of
when you
minimum
fixed it, when this advertisement was done, and when you fix the mark.
well, we fix the mark after the advertisement is put.
So once the game is played, can you change the rule of the game?
Well, I'm grateful, man. The learned single judge relies on the judgment on the ratio of K Manjushri to say that the rules of the game cannot be changed after it has been played. Well, it's in the present case, K Manjushri, where one set of candidates were replaced by another set of candidates. In the present case, 2 posts remain vacant. It is not a case.
Sir, there are 2 aspects. Sir. If you fix a particular criteria that the minimum 50% marks must be secured in an interview to have a to achieve the qualifying marks, then are you not compromising on the merit to some extent? Because if the criteria is that 4% reservation has to be given, and there may be, say, 15 persons who are offering their candidature under that PWD category.
Yes, ma'am.
PD category. Then in that event, in the order of merit, from the ascending to a descending order, you'll have 2 judges.
Well, in the result sheet is at page 119. In the present case, there are 4 posts reserved.
So why did you take? I can understand that before the last date of submission of an application, you have taken a conscious decision, and by way of a corrigendum, you have also
No, it's
uploaded.
not issued a corrigendum. It's an internal.
That is what I'm saying. If you issue a corrigendum as well, that minimum qualifying marks would be 50%. We appreciate that before you apply, you have already done, or before the interview at least took place, you notified it. But once the interview has already done, and then you say qualifying marks, can it be?
My only submission is that
Okay.
this is not a case where there is an attempt to play favoritism. We are not favoring
We
one
don't
set of
know.
candidates. over
What is latent may not be patent all the time.
Because well, it's 2 posts have remained vacant, and those 2 posts will be carried over to the next selection process. It is not a case where you have selected some other person.
I understand then why carrying forward theory. Understand.
Well, then I leave that to your lordship. I have one more submission, Malas. If your lordship may kindly have page 312 of the judgment. The judgment starts at 283. There is one more submission. Below the 50% minimum qualifying mark, there are 2 other PWD candidates who are more meritorious than the.
So take them.
What the single judge has come to hold is that because they are fence sitters, the Odisha Public Service Commission will relax the marks only in respect of the present respondent, and
that we appreciate to the extent. That we appreciate to the extent. Yes, sir, that can't be done. If the merit is the only criteria, whoever is meritorious will get it. That cannot be. There cannot be a pick and choose that somebody who is less meritorious simply because he has approached the court. No. It should inure to the benefit of all.
That finding is at page 312.
The PD class itself is a homogeneous class. Maybe somebody who is more meritorious may not have approached the court, but why will be deprived?
They have not approached the university.
Maybe. Why?
And the post are lying vacant.
So they will fill up. There is no difficulty on the basis of merit.
Merit list.
On the basis of, if you come within the zone, definitely you will come. If somebody is more meritorious than you, then why he should be tried?
That bottom mark will fixed after the selection process.
So that we deprecate. We deprecate to this. No, so whatever the marks is there, you can't challenge that marks after the participation. Then in that event, we will definitely say this cannot be done. But how can you be selected if you are not coming within the zone of merit?
That
can't.
Only 9 posts are being filled up. And rest out of 15 minutes, only 9 posts are being filled up. If the category wise minute, they will fill up the category wise minute. Definitely, I will come.
Mr. Patnaik, only it is discipline number 1. Teachers education discipline. So education education discipline, only 4 PWD candidates, only 4 posts are reserved for PWD candidates.
In category 3, but in some categories, they have appointed excess.
4%.
Logically, having last to page 45.
Has he made out any case that this 4% out of the total vacancy, or a 4% as you argue against a particular stream?
Well, as in all fairness, that is a dispute that is pending in writ appeal before this honorable. The understanding of the OPSC is that in certain disciplines it can exceed 4%. In certain disciplines where candidates are not available, it can be less than 4%.
No. I appreciate one thing, because suppose there are many subjects where the practicals that requires a human skill, and then those may not be very conducive for them because they will not be in a position to do that. I can appreciate to that extent, but this is an education, it's a theory, and the theory, if they are proficient in that, then they can definitely teach that.
Well, it's in one case where there were about a total of 20 vacancies. The OPSC gave recruitment to 5 PWD candidates.
How many vacancies are still left?
But today, in respect of the
out of total 385, 4%.
6 are available.
Under the PWD.
Who can be blamed than you? If you say 4% of each category, the problem would have been solved. But you said 4% of the total vacancies.
Yes, ma'am.
And that you created. If 6 vacancies are there, then I'll have to fill up in any subject.
Your Lordship may observe that.
What can be done? Just imagine you have created a problem. But we appreciate that that should be the way.
But there is a writ appeal pending on this exact question.
That should be the way. That for each category, because then suppose in one, there will be more PWD candidate in one subject than in other. But why you are advertising like this? 4% of the total post. And then you say 15 posts.
Then you invented the problem.
In some categories, they have also appointed excess. Right. Of 5 candidates. Instead of 4, not category 3, they have appointed.
I appreciate it.
I do not see
Why they are doing it, I do not know. Which one is pending? Which writ appeal?
All the posts have been.
Which writ appeal is pending?
I'll give the number. By way of a slip, I'll give it.
From filling up the post until.
This advertisement has been completed. All the posts have been fair. This advertisement has been completed in respect of.
I do not know. Are you going to fill up this post, this vacant post?
These 6 posts
because you will divert it to some other category?
No, as they will not be filled up presently.
They will be carried forward.
They will be carried forward presently.
You will not divert it?
We will not divert it.
Is whether the 4% reservation mandated. Give me that full name. Physical disability. What is that full act?
PWD.
It's the
Physical
Rights of Persons with Disabilities Act 2016.
Correct. Is to be ensured on the basis of the total posts for which the for which the recruitment process was undertaken, or should be adhered to against each category. Stop. By the next paragraph, by the impugned order, the single bench has directed the appellant to give appointment to the writ petitioner respondent under the physical disability category. With categorical observations that other persons who may be more meritorious should not be favored as they did not approach the court. Stop. We are informed by the counsel for the appellant that the point involved in the instant appeal is identical and similar in WA number such and such, which is pending before this court. in order to in order to avoid any conflicting decisions to operate in the field, let this matter be taken up along with WA such and such. Provide the number.
Well done.
So this has been identified. Now they have. So they have to initiate a proceeding against those unauthorized encroachers.
Proceedings have also been initiated.
Where it is now, the notice, show cause and all, everything is not annexed.
If I may refer to the letter which is written by the revenue inspector to the Tehsildar, third page, my lord.
Yes, 11th of
Yes, my lord.
April.
Yes, my lord. Fourth line from second paragraph.
364 of 2025.
Has booked an initial LEC number 364 2025 to 589 of 2025 to evict the illegal and unauthorized encroaches from over the such land.
So now the Tehsildar is the competent authority to initiate the proceedings. To do it, so there's no purpose of keeping the matter pending.
This writ petition has been filed with a prayer to issue necessary direction to the opposite parties to evict the encroachment over the existing drain and within a stipulated period. If it is further prayed that in the alternative, it is prayed that the Tahsildar Mohana may be directed to take necessary steps to what is that letter dated 14/11/2022?
It's Annex 3, page 12. Letter issued by the executive engineer to the Tahsildar.
For demarcation.
Yes.
To act upon the letter number 1195 dated 14/11/2022 issued by the executive engineer NS Division Paralakemundi to the Tahsildar Mohana in the district of Gazpati. It is submitted by Mr. Mohanty Learned Counsel for the petitioner that the petitioner is the Sarpanch of Barapada Gram Panchayat. Step. Mr. Mohanty, sir, yes, Mr. Puspado. Sorry. Mr. Puspala, what is the matter with LIT?
No, this is the case that you came out.
It is submitted by Mr. Puspala and counsel for the petitioner that while letter number 1195 dated 14/11/2022, the executive engineer NS division Paralakamundi requested Tahsildar Mohana in the district of Gajpati for demarcation of the land from KM 69/200 to within bracket Mohana Hilltop Degree College bracket end to KM 111.860 Rajonka of NS 326. And to evict the encroachment over the existing drain at Mohana from Gajapati Junction to Bansadhara River. What are the plot numbers?
But there is no plot number.
Exactly.
There is no plot number. What is ABC number?
That is the land enforcement case. It is its submission that the drain over the aforesaid land has been under encroachment by different encroachers. Considering the submission made by learned counsel for the petitioner, this court, while order dated 9/4/2025, directed learned state counsel to take instruction in terms of order dated 26th March 2025 and to submit the report. Pursuant to such direction, written instruction has been received from the Tahsildar Mohana, wherein it is specifically stated as under para 4.
Pursuant to the same.
Yes. Pursuant to the instruction issued by the Tahsildar Mohana, Revenue Inspector Mohana has already initiated LEC case number 364 of 2025 to 589 of 2025, which are pending before the Tahsildar Mohana for consideration. It is submitted by Ms. Das Learned Additional Standing Counsel that appropriate steps are being taken to clear the encroachment and evict the encroachers at an early date following due procedure of law. Since steps have already been taken by the Tahsildar Mohana for eviction of the enforcement as stated above, as stated in the written instruction referred to above, comma. We dispose of the writ petition with a direction that appropriate steps shall be taken by the Tahsildar Mohana to clear the encroachment and evict the encroachers at an providing opportunity of hearing since the enforcement proceedings as referred to above have already been initiated, we think it proper to dispose of the writ petition PIL. It's a writ petition PIL with a direction to the Tahsildar to see that the enforcement proceeding sees their logical end, providing opportunity of hearing to the encroachers. Opportunity at an early date. Start. The writ petition is PIL is accordingly disposed of.
Item number 4.
Where is the DGP's?
Requesting your lordship's memory, my lord did justice, but my lord Justice MOHAPATRA was not there. Annexure 14. I have read one point. If your lordship will accept it, I am having a case, otherwise I don't have. My lord, I have filed the case challenging the advertisement of 2021.
After participation.
No, I have not participated. I have challenged on the ground that I have not been allowed to participate in the advertisement because of my age.
Oh, age relaxation, yes.
Although in 2004, as per the advertisement of 2004, I was eligible and I have participated, but for the pendency of the case, I could not. So my submission before your lordship was that whether I am eligible to get that relaxation in view of their own, my lord, later.
But now you approach the Supreme Court and the Supreme Court also.
My lord, at that point of time, that was relating to the advertisement of 2004.
And now this is advertisement of
2021.
2021. Now you have crossed the upper age limit. So show us that there is any power to relax the age. No difficulty. Show us any power.
My lord, only thing I want to show your lordship, kindly turn to page 32.
Where within that particular age bracket?
My lord, what I mean to submit before your lordship may kindly turn to page 32.
32, okay. Yes.
Page 32, item number 5.
Okay.
as recruitment of the post of livestock inspector has not been taken up since last 5 years. So the upper age limit may be relaxed by 5 years.
So that is what is the power conferred.
Yes.
In this advertisement, whether it is,
My
that
lord,
is what he really wanted.
My lord, advertisement, there is nothing.
So this is the advertisement.
Yes, 2021.
If the power, there are two sources of powers, madam. If the statute confers a power that the authority can relax, then that power can be exercised. Or at the time of an advertisement, if this power is also conferred, then in that event, there is no difficulty, the authorities can. The only point which troubles me, my brother, if he also joined to me, suppose, can we issue a writ of mandamus upon the authority to act beyond the provision of law or to act contrary to law? Can we issue a mandamus?
That I also cannot submit before your lord.
Yes,
Being
that
a
is
lawyer,
what troubles us, nothing more than that.
the only thing I want my submission before your lordship is that that aspect has not been taken into consideration while disposing of my petition.
We are taking into consideration, don't worry. You show us, we are ready. If you show the power is there, no doubt about it. We will definitely.
Power means power.
That is the
It is not. It is not specified. There is nothing.
What can be done, sir? Madam? Because there are two special bench judgment of Calcutta High Court.
Another thing, my lord, it is also I want to submit before your lordship. After that issue was over before the Honorable Supreme Court, one of the person has been given appointment by the authority in 2019 after disposal of the writ petition SLP before the Supreme Court.
But they must be found eligible in that recruitment process of 2003 or 4.
I was also eligible, but there is one line for which I am suffering.
What line?
One line is there in the Supreme Court order that although I am having the +2 qualification along with training, I have not been considered. I went to Supreme Court that 2004 advertisement, I am eligible. We may be given appointment subject to the result of the SLP. But while considering that, what has your lordship may kindly turn to page 33.
30?
33.
3.
Annexure 9.
Yes.
Annexure 9. Second para. The whole crux, first para, you lordship may last portion, the whole crux of the argument of the learned counsel for the petitioner is that he possesses.
Which one? Page 33.
Page 33, Annexure 9.
Oh, you are reading from the middle of the paragraph. Okay, yes, sir, the whole crux of the argument.
The argument of the learned counsel for the petitioner is that he possesses the qualification as per the advertisement issued on 16/1/2004.
True.
Having heard the learned counsel appearing on both the sides, we are of the view that there cannot be any appointment in violation of the rules. My lord, what is the question of violation of rules that for which I am suffering?
Then the qualification is
to be seen with respect to the rules and not the advertisement inviting application. My lord, I am eligible as per the advertisement, as per the rules also.
Then, sir, madam, the next line is very damaging to you.
That is the factual.
My lord, factually that is incorrect. But
now, how can we go above the Supreme Court? Tell us.
It is not that, my lord, my submission is.
We appreciate, but how can we go above the Supreme Court?
It is not a, my lord, this is not the law.
The Supreme Court in the next line has said that the appellant, means you, admittedly does not possess the qualification as prescribed under the rules. Can we go beyond it?
It's palpably wrong, but
how can we say?
How can we say, madam?
We are bound by that observation.
Fact, my lord, if it is contrary to the fact,
then we'll have to move there.
That has not been done. What can I do, my lord?
Now,
then what can we do?
Our hands are also tight.
Can it be said to be a precedent? Question is, can it?
Always, it's a observation on fact. How can we contradict it?
Madam, it is not a question of precedent. That is binding on you.
Law laid down is the precedent.
No. It is not a law.
It's binding on you.
Binding on you.
That is
It
not-
may not be a precedent.
That is not borne out from record.
No, that is, then you can't say so. We can't.
We can't.
Then I am raising my hands. Your Lordship, Your Lordship, may I?
Now you have raised, our hands are tied.
My Lord, may I submit? Your Lordship may pass the order. Your Lordship may pass the order, but keeping in view my submission so that he might approve the forum and brought it.
Oh, that we will definitely.
Yes.
No doubt about it. No doubt about it.
That again, I only.
Where is the order of the single bench?
Single bench annexure 14, page 50, 50, page 60.
Lako. The writ petition filed by the appellant seeking appointment to the post of a livestock inspector in terms of the advertisement published when?
Your advertisement 2021, that is
Dates, please give me.
37/2021. Page, my Lord, 36.
30th July
30th July
2021. Despite having not offered the candidature because of the disqualification. Stop. The single bench dismissed the writ petition solely on the basis of the observations made by the Supreme Court in the judgment dated 13th February 2017, passed in Civil Appeal number 2689 of 2017. Next paragraph. The petitioner, the appellant. Now, previously, the appellant also offered his candidature pursuant to the advertisement made in the year 2004 for filling up the identical post, but was not favorably considered by the authority. The approach to this court could not yield favorable result, and ultimately the petitioner filed the special petition before the Supreme Court, and after the leave having granted, the said civil appeal number 2689 of 2017 was registered. Undisputedly, the civil appeal is ultimately dismissed by the apex court on 13/2/2017 with the categorical finding that the appellant, admittedly, does not possess the qualification as prescribed under the rules. Stop. The counsel for the appellant fervently submits that the appellant possesses all the eligible qualifications required for the set post, but because of the age bar, he could not offer his candidature. Stop. It is further submitted that the findings returned in the judgment dated 13/2/2017 by the Supreme Court is factually incorrect, and therefore no credence should be given thereto. Stop. We have very succinctly, we have recorded your submissions. Next. It is next one. It is undeniable that the petitioner has crossed the age limits set forth in the advertisement for filling up the said post in terms of the provisions contained in Odisha non-gazetted veterinary technical services within bracket recruitment and condition of service bracket close rules 1983
1997, that has been amended.
as amended from time to time, and lastly in the year 1997.
Not time to time, only 97.
Yeah, 1997. We invited the attention of the council for the appellant to place before us any provision under the said rules which confers the power upon the authority to relax the age for the purpose of recruitment to the aforesaid post. It is fairly submitted that such statutory rules does not contain any such powers, but she invited the attention of the court to an advertisement published for the said post in the year 2004, wherein the power to relax the age bar was duly mentioned. According to the counsel for the appellant, if such power was reserved in an earlier advertisement, there is no justification that such power cannot be exercised by the authority in a subsequent advertisement. We are unable to accept such proposition for the simple reason that the recruitment process is undertaken by a statutory authority on the basis of the rules framed in this regard. The authorities cannot act beyond the circumference of the provision of the statute, nor should be permitted to transgress its peripheral. The authorities must act within the precincts of the statutory provisions and cannot travel beyond it. At times, the authorities may indicate the relaxation of certain conditions, provided the provisions in the statutory rule does not expressly forbid the same. If the provision contained in the statutory rules forbears the authority to go beyond the scope thereof, even if such power is assumed, the same is contrary to the law, and therefore the authorities shall not be permitted to take recourse thereto. Even if the mistake committed at one point of time shall not be permitted to be committed perpetually, nor the writ court should issue a writ of mandamus upon the authority to commit the mistake or to act contrary to law. In absence of any express powers conferred in the statutory rules, the authority cannot assume such power, and therefore we do not find any justification in the stand of the appellant that there is no fetter on the part of the authority to relax the age barriers. Even apart, the advertisement for filling up the said posts published in the year 2021 does not contain any such provisions or any such stipulation that the power is reserved upon the authority to relax the age bar, and therefore, in absence thereof, the participant or a prospective participant cannot compel the authorities to do a thing not contemplated in the advertisement. Full stop. So far as the second point is concerned, we do not feel that it needs any further discussion, for the simple reason that in an order, in a judgment dated 13/2/2017, the apex court unequivocally observed that the appellant does not possess the qualification as prescribed under the rules, and therefore, even for argument's sake, the contention of the appellant is accepted that the authorities can relax the age barriers, yet he cannot succeed having not acquired the eligible qualification prescribed under the rule. The contention of the counsel for the appellant that such observation is factually incorrect cannot be looked into, as every observation made by this apex court on facts is binding on the litigant in all the subsequent litigations, nor the High Court or the court at the district level can take such contrary view. In the event the factual error is perceived in the judgment and an order passed by the court, the remedy of such litigant is to approach the same court, inviting the attention of the learned judges in that regard before such event fades from the memory. Within brackets, C, State of Maharashtra versus Ramdas Srinivas Nayak, AIR 1982, Supreme Court, page 1249, bracket close.
Yes, I have gone through.
Full stop. Next. The observation made by the apex court is sacrosanct so far as the facts are there, unless the same is reviewed and or modified by the same court, and it is not open to the High Court or the district courts to take a contrary view in this regard. Furthermore, the apex court further observed that there cannot be any appointment in violation of the rules, which should also be considered in a pragmatic manner to mean that if the rule is silent on the exercise of power by the authorities to relax any of the conditions of the recruitment, the authorities cannot usurp such powers. Stop. From whatever angle we look at, does not find the ultimate decision taken by the single bench to be infirm and or illegal. The appeal is thus dismissed. No.
Please.
Item number 6.
Sir,
petitioner is an association.
he is a trade union. Yes. He's a trade union.
Trade union secretary of the trade, represented by the secretary.
Yes.
Well, the brief fact of the case is, I will take your worship to a background, that the petitioners were engaged right from 2018, in pursuance of a directive of the Reserve Bank of India as business correspondent attached to the banks.
No, it's a trade union cannot be a business correspondent.
No. Members. They are the members of the trade union.
Okay. So the business correspondents, they constituted or formed a trade union.
Yes.
Okay.
So they were appointed on contractual basis, admittedly, renewable from time to time, right from 2018 onwards.
Yes.
Then, while they were continuing, they were getting remuneration on a fixed remuneration basis. So that remuneration pattern was changed, and they were agreeing by certain other conditions. Therefore, they served a strike notice. The appropriate authorities entered into conciliation. Conciliation having failed, there was a reference. While the reference was pending, the bank came out with a request for proposal, giving an advertisement, inviting proposal for selection of corporate business correspondents by an outside agency. So apprehending that there will be their services will be placed, terminated, and or will be placed under an agency and not directly under the bank, they approach this court challenging the said notification. The Honorable single judge framed several issues. And here, first, that at the behest of the association, the petition is not maintainable. Then second, there is no employer and employee relationship between the members of the union and the bank. Then the third is that this appointment is made in pursuance of a policy. This advertisement is made in pursuance of a policy of the Reserve Bank, and the court doesn't have the power to interfere with the policy decision. I am challenging the said decisions. Mainly, Lord, your Lordship, let me first take your Lordship into.
The first question is whether the trade union can maintain a writ petition.
Yes, Lord. But if it
can, then definitely we will enter into the merit. If it cannot, then we did not have to dilate on the merits. We will fail on that score.
They have given us several decisions. They have taken several decisions and ultimately came to a finding that you cannot maintain a writ application below. First, in order to appreciate, may I draw your Lordship's kind attention to page 65 of the writ appeal.
Yes.
That what was the dispute pending before the
conciliation officer?
No, CGIT.
Central Government Investigations.
Conciliation failed. That's what there was a reference.
So it is the reference is pending before the appropriate government.
Yes. Look at 9.4. This court, upon conjoint reading of the above statutory provision, finds sufficient force in the submission of Sri Manoj Kumar Mishra and senior advocate the issue whether the BC, that is the members of the association.
Mr. Mohanty, you are referring to page 62, page 65.
Huh?
You are reading page 65.
Yes, ma'am.
Which paragraph? 9.4.
9.4.
Yes. Yes, please. Sorry.
Page
65.
65.
Yes, ma'am. This court, upon conjoint reading of the above statute.
Just a minute.
Has your Lordship got it?
Yes. 9.4.
Yes.
Yes, please.
This court, upon conjoint reading of the above statutory provision, finds sufficient force in the submission of Manoj Kumar Mishra, learned senior advocate, that the provisions relate to undisputed fact of employees having raised the dispute before the forum mentioned therein. In the instant case, the issue whether the BCs, that is business correspondent, engaged on the basis of agreement for a period of 1 year, subject of course to renewal, would be treated as employee.
Sir, what we were really harping on, the maintainability of the writ.
I am coming.
These are the merits, whether the individual whose right is affected, whether he can come collectively before the court, is the another issue. That is, we are not concerned.
Yes.
We are simply concerned whether the trade union.
Here, Lordship, see the reasoning where you have 39. Page 39.
Page 39 of the
Lord, here, Lordship, page 37 onwards, Lord, is the finding of the regarding the maintainability.
So 37.
Page 37. Has your Lordship got it?
Yes, we are reaching
8.3.
37. Yes.
8.3.
Yes.
The revision of the record reveals the following fact. In the cause title of the petition, the petitioners have described itself as Orissa Bank and Business Correspondents Association, represented through the General Secretary Sri Prabhakar Barik.
Oh, this is relating to authorization.
The affidavit portion of the report depicts as follows: that I am the General Secretary of the petitioner, that the facts stated above are true to the best of my knowledge, those born outward. No pleadings, page 38 is available to demonstrate that the members have authorized the General Secretary of the Orissa Gramya Bank Business Correspondent Association to file the case of present nature, nor is there...
No, we got it, sir. We got it. We got it.
That is not the only ground. There are several other grounds.
Yes, there are several other grounds and few number of decisions total. Nothing is stated by the petitioner Orissa Gramya Bank Business Correspondent Association depict that there was any resolution of the association to question the decision of the OGP versus cursory glance at the copy of the agreement dated, that is the agreement engagement letter. 5620 enclosed depicts Prabhakar Barik in his individual capacity entered into agreement with Orissa Gramya Bank. No list of members is available in the petition, or was it produced. In the Bhaklatnama executed in favor of Sri Devendra Mahantal, and the advocate for the General Secretary of OGBBCA has put his signature and seal, but the record doesn't reveal whether the General Secretary was competent to execute the Bhaklatnama and he was authorized by the association with respect to filing of the present case. There is no declaration, nor does any document evince that in case an order is passed against the petitioner, all the members of the Orissa Gramya Bank Business Corporation would be bound by such decision. Therefore, this court finds force in the argument of the senior advocate, Manoj Kumar, present on behalf of the Orissa Gramya Bank, that the Orissa Gramya Bank Business Correspondent cannot pursue the matter on behalf of the business correspondents engaged by the OGP by existing agreement in the then without goes on putting various decisions. This is one. And if admitted, the second point is that if admittedly the dispute is pending regarding the relationship, employer-employees relationship and remuneration before the CGIT, without any finding that there is no relationship of workmen and employees, will affect totally the merits of the case. When now before the Central Government Industrial Tribunal, with all respect, the Honorable Single Judge should have confined all the In fact, there was a resolution by the association which has been executed before the tribunal. But I have not.
Sir, we feel that the point is to be heard, but there is one aspect. Kindly consider both of you. There was a failure of conciliation proceeding.
Yes.
The matter is now referred and it is pending before the labor court, industrial labor court. I think whatever the point you have in your pocket or in your armory, you can agitate that point before the labor court.
It is one thing,
So it is competent to decide all those issues. There is no difficulty.
Right, my lord.
So it is better that we will interfere with this order on some limited score and relegate you to that proceedings and let that be decided.
My lord, that aspect is brought to the notice of Lord Counsel for the petitioner again and again by the Honorable Civil Judge as referred again and again that if you insist on it, then I'll have to give finding on merit because
that will have the impact on that particular decision.
You will see the judgment of the Honorable Civil Judge.
In case it is necessary, I have placed detailing the judgment. My humble submission is that the Honorable Single Judge ought to have confined himself to the challenge to the request for proposal instead of delving into.
Sir, that was the major issue before the conciliator.
Yes.
That was the major issue before the conciliator. And the conciliation failed. That means that this dispute is now referred to a court to be decided.
Yes.
So why you approach the rate court and
while that was
and the simultaneous proceeding, creating a problem here.
Page 107, para 11.
Please, Mr. allow me.
No, only I am concerning you, Lord.
I just invited his attention whether he is agreeable to this or not. We will not definitely close down.
Telling them your lordship is raising a question that why
question.
If a doubt arises in your lordship's mind,
no doubt. What we feel is that
why should I approach simultaneously two forums? But why I approach the read court? But the reference was pending during the pendency of the
but now it has
reference
now it has gone to the court where the court will definitely decide it. So this was a subsequent event.
Like if I am thrown out by if I do not challenge this tender notice, and if some outside agency is engaged, then what would be the meaning of this?
When a reference is pending, where you are a concerned workman, can you be thrown out? Or your service condition, can it be changed without the permission of the tribunal?
That is one of
that is
one of the
already competent.
All right.
I am aware of 33.
Sir, we have learned from you.
Not that I am not aware. But I have also thought about the matter.
That is what we also think that problem is, sir, with deepest of respect, what is happening is that if you invite the court, the writ court to go into those aspects, incidentally or accidentally, if any observation is made and which has some bearing on that particular issue to be decided by the tribunal, that would create a problem so far as your client is concerned.
No, it has already created a problem.
We were thinking about it, that if we interfere with this order and keep everything open and to be decided by the tribunal, I think it will be a fresh lease of life to you, to your client. Ponder upon it, think about it. Please ponder upon it, because we can keep all the point open, treated it to be undecided, and then if you say,
is it any time convenient in the next week?
Subject to your convenience, sir, tell us. We are always open, no difficulty.
With grace of God, I am still available.
Then let it be.
We are lucky that you are.
Anytime, tell me which date suggests.
Any date I cannot.
Date. 23, 24, what? 23. 23, sir, that will do? 23rd?
Yes.
23rd. Okay.
Put up this matter. Appeal, read appeal on 23rd April 2025 for further hearing. Please ponder upon it. Why? Only, not for further hearing. Here.
Item number 7.
Just a minute. Just a minute.
May I please? The appellant is a state-owned PSU coming under the administrative control of the PE department, Public Enterprise Department of the state. For the purpose of payment of gratuity, the appellant is a corporation, my lord, OSFC, State Financial Corporation. For the purpose of payment of gratuity, the corporation had its own regulations.
Now the interest has been.
My lord, the interest
at the time of delay.
at the time of delay, my lord.
Delayed disbursement of the gratuity.
Delayed disbursement of the
But
gratuity.
the Payment of Gratuity Act, what it says.
My lord, I am coming to that.
And there are a Supreme Court judgment which
My
the law.
lord.
It says that the gratuity has to be paid on the date of superannuation.
My lord, I will.
Exception is that there may be a competing circumstances which may invite the delay.
That is what is the case, my lord, here, my lord.
So that's the only exception. Otherwise,
My lord.
it's a valuable right. It's
a right, my lord.
I would not go that far that it is a property.
My lord, the corporation had its own regulations. Its own regulations. The payment of gratuity to employees regulation 1968. In 2010, with permission of the prior sanction and permission of the state government, the corporation adopted the Payment of Gratuity Act. My lord, may kindly come to Annexure 1 to the writ application, my lord.
Read petition.
Read petition, my lord. Read petition.
Annexure 1.
Annexure 1 at page 13 of the read petition, my lord. In exercise of powers conferred under section 48(3) of the State Financial Corporation Amendment Act 2000, the Board of Directors of
Just a minute.
Page 13, my lord.
Adoption of the Payment of Gratuity Act.
Adoption of the Payment of Gratuity Act. But what I beg to submit, my lord, your lordship kindly peruse State Financial Corporation in consultation with the Small Industries Development Bank of India and previous sanction of the state government. And that is important. That I am coming.
Sir, once the Payment of Gratuity Act is adopted, that means it adopts, it's all the provisions of the Payment of Gratuity Act.
All the provisions
imbibe into a system with lock, stock and barrel. You cannot say that one provision will not apply or other.
No. I don't say that. It went on like that. Payment of gratuity was there. In 29/3/2018, my lord, Payment of Gratuity Act was amended.
Yes. Who was that provision? Straight away from payment.
Raising the limit to 20 lakhs, my lord. That is
what is the disbursement?
My lord, disbursement. Delayed. My lord, the respondent number 1 was superannuated done. superannuated on 34/2018, my lord.
30?
30/4/2018. April 30th, 2018, my lord. Immediately he was paid with 10 lakhs, what was payable as on the date. Because the corporation was not competent to implement the amended provision, my lord, without state's approval.
No, Mr. Patnaik, you are not.
This was
29/3/2018,
sir. This notification.
Yes, my lord.
In 2000, so this was in place. So
My
you
lord.
can't say that once this is notified in an extra budget of the state.
My lord, for implementing
Then it takes effect from the date of its notification.
My lord, may kindly come to page 14, annexure 2 to the writ application, my lord.
Yes, annexure 2.
Annexure 2.
Yes.
The corporation, my lord, as
2020 writing.
Pardon me.
2020, the corporation is writing.
Corporation took steps, my lord. Various steps. Then, my lord, to the controlling department. Controlling department says that you take permission of state, my lord, the finance department. Finance department concurrence was required. But then annexure 3.
Mr. Patnaik, your interdepartmental communication will not take away the effect of law.
No, it can't be.
No.
What
Once you adopt Gratuity Act, all amendments subsequent thereto are applicable to it.
Yes, applicable to it. But
no permission or no private previous sanction of the government or finance department.
But kindly have the glance back. They insist upon me that you take concurrence. Without concurrence, you cannot. My lord, my controlling department, P department, my lord, the lordship may kindly have a glance at annexure 2. It's a clear-cut direction.
Then why are you challenging it? Then why, Mr.
Can I question my boss?
Why do you challenge? Then if so you are not concerned whether the compensation is granted or not. You are ready to pay. You are ready to pay the gratuity.
It is paid.
It is paid.
It is paid.
It is paid. So no, but there is a delayed payment.
There is a delayed payment.
Yes.
And delay is this, my lord, due to the government process, my lord. That is the
right for sanction of fund to the PA department, to our controlling department. It is there. So you are not agreeing. As it is, you are not agreeing.
Agreed, my lord. It's going from the corporation's fund, my lord.
That is what the subsequent orders are there, sir. You flagged an issue and it was adopted that it will be the cutoff date would be 29th of March 2018.
Yes.
16 annexure 14 is
Yes.
the board resolution accepting the implementation of back date.
Yes, it was accepted.
What more?
It was accepted, and my lord, 20 lakhs was paid. There is no doubt. There is no dispute over that. My lord, only
He has given the entire life to you.
the delay.
He has given the entire life to you, sir. Be compassionate.
That's it, my lord. Yes, he has received it.
Why not?
He has received it. Only the question, my lord, this is the thing, what my lord said.
Page
Yes, there is a book.
annexure 4.
Yes.
16 annexure 4.
Page 16.
Roman I.
As page 14, my lord. 16, I'm sorry. Whenever that sanction was obtained, my lord, board took a resolution. As a model employer, my lord, the board took a decision, immediate decision.
20 lakhs.
And my lord, the next year,
He accepted, then also he will.
It is your board's resolution.
yes, my lord. So after obtaining the approval, board resolved that it is.
But you have given a particular date.
Yes.
Date is prior to his retirement.
Date is 29/3, my lord, the date of commitment.
It is prior to its retirement.
Yes, it is prior to department. What I beg to submit, my lord. What I beg to submit, my lord, the delay was genuine and my lord unintentional.
No.
And my lord beyond my control.
No.
You unnecessarily flagged an issue. There was nothing which could. The moment the notification was done in 2010, There was nothing which can prevent you from doing that.
My lords, I was not paid 20 lakhs at the beginning, my lords. They paid 10 lakhs only. I had to file a
That,
petition, my
Mr. Biswal, he has already
My
admitted
lords,
that.
my lords.
And admitting that you are entitled to 20 lakh, that has also been paid. But
Yes.
there is a delayed payment.
My lords.
That then he, when admittedly you are entitled to more amount of gratuity, he paid it, and there is a delay, he is liable to pay compensation. There is
Section 4 is very clear of the payment of gratuity act.
Section 3, my lord. Section 7. My lord, may kindly have a glance at section 7.
Please come to 4 first.
Yes, my lord.
First, subsection 1 says the gratuity shall be payable to an employee on termination of his employment
Yes.
after he has rendered continuous service for not less than 5 years. So he has rendered more than 5 years. When on his superannuation,
Unisub.
so you have not paid, or on his retirement or resignation, you have not paid retirement, or on his death. That's not a case.
That is
So
not the
it
case.
is a case of superannuation or a retirement.
Retire.
And then provided that completion of continuous service of 5 years shall not be necessary when the termination. So this is not a case.
No, this not.
Provided further in case of a death, this is also, this proviso does not
No,
apply.
it does not apply.
His
Then-
entitlement, my lord, I don't quarrel with.
So it is, if it is paid on the date of retirement or superannuation, then
My-
it's very from your responsibility.
No,
Now
my
you are
lord.
telling us to come to 7.
7.
C7
7.3, my lord. Subsection 3.
first.
Section 7, subsection 3.
Yes.
The employer shall arrange to pay the amount of gratuity within 30 days from the date it becomes payable to the person.
You will be exonerated from an interest up to 31 month, that is 30 days. So 1 month only,
My lord, what I beg to submit,
not beyond that.
that the
Even if we accept 7.3.
amount payable was 10 lakhs as on that date.
No, it was payable was 20.
20 lakh.
It was, you paid it 10. Then you raised flag an issue that whether I should pay 20, the finance department very categorically says, what are you saying? This notification has come, you are supposed to pay 20. Then the board resolution, you fix the cutoff date. I do not know whether anybody challenged that board resolution or not. We are not entering.
No, they
into
were
that.
paid by that. Immediately they were
We
paid.
are not going into that.
My lord.
Whether that was justified or not, we are not going. But still, even if we go by the board resolution, the cutoff date was 29/3. He retired on 30th of April to after that, 1 month. So you are supposed to pay.
What I beg to say, my lord, submit, my lord. This
is that very difficult. And
What-
the Supreme Court in many cases have already said valuable right
Absolutely.
that cannot be taken away.
No, it's a right. It's a right, but my lord.
And it is not a bounty
No, it's not about.
or a charity. It is in fact a deferred payment of a salary.
What I was submitting, my lord said that I may be permitted to raise that issue with the controlling department to.
No, why you will, sir, you'll have to pay
That
him, then do whatever.
Whatever you like, whatever you are advised.
Take the issue somewhere else, we don't mind. Because you're employed, he has given entire life to you.
My lord, that's it.
So you have to be a model employer.
As a model employer, they immediately, my lord, they implemented as soon as the approval was obtained.
Yes, but do suggest.
I suggest, as your lordship was saying that I will, for arrangement of funds, let the matter be taken up with the
Do
controlling
you want to
department.
withdraw the appeal or will pass orders on merit?
Because the sections are very
clear.
You cannot
All right.
take your response. The section is very clear. And then board resolution is against you. You want board.
Board.
That is what wrong.
Petitioner in this, the appellant in this intra-court appeal calls in question the judgment the order dated 17/12/2024 passed by learned single judge in WPC number 17221 of 2024, wherein the appellant was directed to pay interest on the delayed payment of gratuity to the writ petitioner respondent. Step. Mr. Patnaik, learned counsel for the OSFC appellant, submits that on the date of retirement, on the date of superannuation of the respondent, writ petitioner respondent, that is on.
I was the answer, man. I was the writ petitioner.
You are the
ML.
Oh,
The corporation was the writ petitioner.
okay. Mr. Patnaik, under counsel for the OSFC appellant, submits that on the date of superannuation of the respondent number.
Respondent number 1, man.
Respondent number 1.
So,
sorry, respondent. On the date of retirement of the respondent, comma, that is on 30th April 2018, he was paid the gratuity of rupees 10 lakh. Stuff. It is its submission that initially payment of gratuity act was not applicable to the corporation, OSFC, Orissa State Financial Corporation, for brevity the corporation. But why Gazette notification dated, what is that Gazette notification dated? 1st July, 7 July 2010. The corporation, with previous previous sanction of the state government, adopted Payment of Gratuity Act. Sir, since the respondent was entitled to with effect from 1st January 2010, adopted Payment of Gratuity Act with effect from 1st January 2010. Step. Thus, on the date of superannuation of the respondent, he was paid the gratuity of rupees 10 lakh. Step. In the meantime, the Payment of Gratuity Act undergone an amendment in the year
2018, with effect from
29/3/2018.
29/3/2018. Thus, there was interdepartmental communication between the corporation and the parent department, namely Public Administration Department, Government of Odisha, to sanction the amendment in the provisions of the Gratuity Act, enhancing the gratuity amount from 10 lakh to 20 lakh. Thus, there was interdepartmental communication between the corporation and the parent department, namely Public Administration Department, Government of Public Enterprise Department, Government of Odisha, to sanction the additional amount of additional differential amount of rupees 10 lakh to be paid to the respondent. Step. Thus, there is a delay. Sorry, accordingly, the additional amount differential amount of rupees 10 lakh was paid to the respondent on Mr. Mishra. So on so. Stuff.
It was transferred, my lord, to the bank's account to the.
When? Stuff. Thus, there is a delay in payment of differential amount of payment, differential amount of gratuity to the respondent. The delay in payment of the differential amount cannot be attributed to the corporation as the same could not have been paid without the prior sanction of the parent department as well as finance department of Government of Odisha. Learned, although the issues, then what was your challenge in the writ petition?
The same issue, my lord, that I am not liable for interest in view of that intergovernmental decisions, my lord, pending with the government. My lord, that was not considered by the Honorable Single Bench.
Mr. Patnaik, the corporation raised the aforesaid issue before the learned single judge, that to the effect that it is not liable to pay the compensation, interest of rupees 3,64,846 as awarded by the appellate authority, under the Payment of Gratuity Act. Learned single judge it is submitted that learned single judge, without considering the case of the appellant in its proper perspective, dismiss the writ petition. Hence, this writ appeal has been filed. It is submitted by Mr. Patnaik, learned counsel, that it is further submitted by Mr. Patnaik, learned counsel, that the delay in payment of gratuity was bona fide because the corporation had submitted proposal for payment of the differential amount of gratuity in due time. Due to delay in taking a decision, sanction by the parent department, some delay occurred in payment of in such payment. This material aspect, so section 7.
Section 7.3. Section 7.3 is what
7.3 is the amount payable.
Patnaik learned counsel refers to section 73, 7 within bracket 3 of the Payment of Gratuity Act. First the Act 1972, first the Act, for brevity the Act, and submits that how it is applicable to you?
Applicable, my lord. Let's say I find it is there, the date it becomes payable. My submission is that the date, as in the date of superannuation, payable amount was 10 lakhs due to want of sanction. It was not 20.
Okay.
That I was trying to
and submits
bring home.
and submits that on the date of superannuation of the respondent, an amount of rupees 10 lakh as gratuity. The payment lakh towards gratuity was payable to the respondent, which was complied with immediately. Subsequently, after sanction of the PE department, the gratuity, the differential gratuity of rupees 10 lakh was paid.
Your Lordship, it was not 10 lakhs. It was the differential gratuity is 7 lakhs 33,713 rupees, which was paid on 5/5/2023.
Differential amount of gratuity was paid to the respondent on
5/5/2023.
5/5/2025. 5/5/2025. 23. That is 23. Which was within 30 days from the date of sanction of the PE department. Thus, the appellant was not liable to pay any interest as directed by the appellate authority under the Act. Mr. Vishal Lanet, he therefore prays for setting aside the impugned judgment. Impugned order. Mr. Vishal Lanet, counsel for the respondent, vehemently objects to the same and submits that Section 4 of the Act makes it clear that the employee should receive the gratuity on the date of superannuation. The respondent should have received the gratuity amount on the date of superannuation. But the respondent superannuated on 30/4/2018, and the differential amount of gratuity was paid on 5/5/2023. 5th May 2023. Thus the single bench has not committed any error in confirming the order of the appellate authority directing the corporation to pay the interest on delayed payment of gratuity. Delayed payment of differential amount of gratuity. Yes. I'm blessed. We considered the submission arrival contentions made by learned counsel for the parties. Section 4 of the Act reads as under. The case of the respondent comes under Section 4A of the Act. Section 4A, which speaks 4(1)(a), which provides that the respondent should have received the gratuity on the date of his superannuation, admittedly, undeniably, the respondent was paid rupees 10 lakh towards gratuity step, but the board's decision, but the decision of the board of the, but sorry, but the, but there was that there is, but stop. In view of the amendment, to the Act in the year 2018, that is, which came into effect from came into effect from 29th March 2018, the petitioner is entitled to a higher amount of gratuity step. As such, the petitioner, respondent, as such, the respondent should have been paid the entire amount of gratuity on the date of his superannuation. In addition to the above, the board of the corporation also took a decision on 29/3/2023 to pay the enhanced amount of gratuity in view of the amendment to the Act step. Thus, there was no difficulty on the part of the corporation to pay the entire amount of gratuity on the date of his superannuation step. But taking the plea of interdepartmental communication, there was delay. Sorry, the corporation delayed in payment of gratuity to the enhanced amount of gratuity to the respondent. Step. In view of the above, we are of the considered opinion that the order impugned in this appeal, order of single bench impugned in this intra-court appeal is warrants no interference. Accordingly, the writ petition, writ appeal being devoid of any merit stands dismissed. Oh, okay. Seven 3 capital A of the Act provides that if the amount of gratuity payable under subsection 3 is not paid by the employer, namely the corporation, within the period specified in subsection 3, the employer shall pay from the date on which the gratuity became payable to the date on which it is paid, simple interest at such rate not exceeding the rate notified by the central government from time to time for repayment of long-term deposits as that government may by notification specify. Step. The entire amount of gratuity, including the amount paid belatedly, was required to be the respondent employee was entitled to receive the entire amount, including the differential amount paid belatedly, differential amount of gratuity paid belatedly on the date of superannuation in terms of section 4(1) within bracket small a of the Act. Admittedly, the differential amount was paid belatedly on 5th May 2023. Thus, we find no force in the submission of Mr. Patnaik and the counsel for the appellant. As such, the impugned order passed by learned single bench warrants no interference. Hence, the appeal stands dismissed. Accordingly, the appeal stands dismissed. Yes.
Number 8. Fine, sir. Item number 8 and counter is fine, sir. I have received the paragraphs from the counter. Pray for next week. I'll file my. By next week, I'll file my counter.
Fortnight.
I've received the paragraphs. I have sent, prepared the.
Mr. Patnaik, on the last date, we asked you, when can you file? You confirmed the date. Thereafter, we gave you the date.
I'm sorry for that. The word positively has to be considered. I'm sorry that whether use the word positively means that by that day you should. I'm sorry I couldn't.
All right. Mr. Patnaik, learned counsel for Mahanadi Coalfield Limited, prays for further adjournment to file the counter affidavit, submitting that he has already received instructions in the matter. When can you file?
By 23rd, I'll file.
By 23rd. Let the counter affidavit be filed by 23rd April 2025 as undertaken. Survey copy thereof on learned counsel for the petitioner put upon 30th April 2025.
Item number 9.
This is the public interest litigation.
The report.
There is some development from their own department. Their own department asked the Tahsildar and the concerned authority to evict the owners of occupied.
They have identified the encroachers.
We have written to the Tahsildar to first demarcate the land.
That is what is required. First the demarcation, then identify that who are the encroachers, and then the initiate the proceedings.
Yes. And Your Lordship, that road for the construction of the road, the tender has been cancelled and they are now preparing for a fresh tender, Your Lordship, invite fresh.
Because it is not encroachment free.
No, first the Tahsildar will demarcate the land, then.
No, the construction of road.
Yes.
It could not be made because it was not encroachment free.
Yes, Your Lordship, because of local unrest they couldn't.
Exactly.
So that has been cancelled, no payments have been made. They will invite a fresh tender after the Tahsildar demarcates and the enforcement.
2019.
19, but they are.
6 years.
10/6/19 document number 3, page number 3, 10/6/2019.
Those are
10/6.
tender
Page number 3 of the document.
for the repair of the road, Your Lordship.
No. 10/6/2019 document number 3. Their own letter.
You are saying not possible on the part to give a layout without demarcation of a ROR. When you will do a demarcation?
It is within the domain of the Tahsildar.
Your Lordship, that has been.
What is the difficulty? For last 6. Why? Is there any water body or any geographical barrier? Then
It is a district road, Your Lordship, other district road. It is not a
then
national highway.
why? What is the problem?
They have now written, they are taking steps, they've also written BMC.
That is a
the
vague.
demarcation and
that-
limitation.
that-
Because
That is
the
as
local
vague as
language,
sky.
things
That
could-
statement is as vague as sky.
Lordship, because of.
Taking
local-
steps, what steps? That
because
he
of
should
local
mention that what
language,
step he is
Lordship,
taking.
they couldn't Proceed, now they are proceeding, they have cancelled the tender and they are going to invite a new tender after the Tahsildar.
For everything you need the intervention of the court.
Because of local unrest, Your Lordship, they couldn't do previously. That is what I mean, given an instruction, Your Lordship.
Madam,
Lordship
you
will
know,
permit and file a detailed
you
complaint,
know
Lordship.
how to deal with unrest, public unrest. You are the executive officer. You are the executive magistrate. You know how to deal with. Tahsildar has been conferred with the power.
Madam, so far as the public order and its maintenance is concerned, it is within the state list of the seventh schedule. It is your duty how to maintain it. Why every time the court would remind you of your power and then you will do it? In 2019, your own department says that the demarcation is necessary.
Yes, Your
On
Lordship.
10th of June 2019.
Yes, Your Lordship.
Now we are in
What is the
the
period of
middle of the March 2025.
Your Lordship, that
4.5
period
years have
COVID,
elapsed.
Your Lordship.
And development work is
And therefore, the Tahsildars and all were also input to other official duties, Your Lordship. But for the whenever they
Don't-
tried for that
don't
public,
take- please, madam, don't take that. Please.
Your Lordship, we were in the court, Your Lordships are fully aware of that point of time, what the district administration was
Are the difficulties
had
that
faced
you-
at that point
then
of
the
time. So
matter that
any
will-
instruction that have taken place,
that implies that the police administration is not
no, Your Lordship.
competent enough.
No,
Then
Your
that would
Lordship.
imply if they cannot maintain a public order, then what does it mean? Say the commotion.
But the
There might not be any
tender had
requisition.
floated that at that point of time, Your Lordship, so that work could not take place. 2 years have elapsed, so they have now cancelled that tender. They are starting afresh, Your Lordship, after the Tahsildar demarcation.
Because the tenderer who will come, he will flag an issue that these are the encroachment. How can I make a?
They have intimated, what my instruction says that they have intimated to the authorities and to the GA department also, Your Lordship.
Calculus and there are procedures, the procedures are going to be completed. Because when the 15 to 20 villages are suffering.
Really give us confidence in us that it will be done.
It will be done. It will be done. Your Lordship.
There is a document that you have already approved the Tahsildar,
Lordship.
writing a letter.
That is my lord.
Given you instruction.
Now.
29/1/2019.
He said 2024, 2025. nothing-
Yes,
nothing has been done.
2019.
These are all.
Now they have rescinded the contract was there, Your Lordship. Now they have rescinded the contract and no payments have been
They
stopped.
might have cancelled or rescinded the contract. There is no doubt about it.
Now they
But what
start
about-
afresh, Your Lordship. They will now.
First thing is the demarcation.
Yes, sir.
Second thing is the identification of the encroachers. And the third would be the removal of the encroachment.
Lordship, for that, the police and the BMC have to be involved, Your Lordship.
And
That's why the letter 10/6/2009.
They are now taking proactive steps here.
That's why the 10/6/2009.
was the document that really proactive steps are
I
taken.
will, Your Lordship will give me some 15 days time. I will file an affidavit to that effect, Your Lordship.
May I say one thing? Your Lordship may direct portion to the letter 10/6, referring the letter 10/6/2019, my lord. My lords may direct the appropriate authority to take it. But his lordships will know our of this matter regarding the, because the land belongs to the GA department. Then it has been
Come to
belongs to G department. It is handed over to the R&B.
Department, General Administration Department.
Then it is handed over to the R&B, road and building. So road and building, that's why because the land road come under the R&B. The R&B, my executive engineer, R&B, IB has been direct, opposed the authority to evict the authority.
Could not get a piece of land over there. And you could not get a piece of land over there.
Out of court with humble to my lords, because there are some builders, my lord, encroachment, they are not taking steps. The whole problem is 4 to 5 builders are the best of those builders, my lord, they are not taking.
Under the BMC.
Yes, your lordship, it's coming under proceedings.
That's why my lord, the letter 10/6/2009. It has joint enforcement committee.
Everything is with you. Here department land.
6 builders are opposing or in fact the construction.
Please, Mr. Mian.
Sorry.
Have some patience.
You have already denied. Sprinkle more blessings from a devastating fire.
No. Because get
you have been successful in that.
You may injure yourself.
No.
That.
Madam, show
It's
some
time
kind
and
of
file
some
details
kind
after
of-
that. Also, requisite, and it should also, your lordship, letters and briefs. They have opted, the instructions, your lordship, that the intercommunication of the DA department, BMC.
Serious allegation pertaining to an encroachment over the government land, creating impediments in construction of a connector to the national highway. The present public interest litigation was taken up. On the last occasion, the direction was passed upon the state to submit a report indicating as to whether there is any legal occupant over the government land where such a road is needed like a connector to be constructed. Though the writ petition was filed, though the writ petition in the nature of a public interest litigation is of recent origin, but today, what's the good name, sir? Mr. K.K. Bhuya, the learned advocate for the petitioner, hands over the internal communication between the different departments of the government. Exchange in the year 2019, indicating that the attempt to make a demarcation of the record of rights was felt inevitable, and the steps were directed to be taken in this regard. Yet no steps have been taken till date. Though the aforesaid the internal communications do not form part of the reputation, taking the gravity of the situation, more particularly the litigation being a public interest, we take note of the same and invited the attention of Miss. What's a good name, madam?
Mrs. Suman Patnaik.
Miss Patnaik. He submits that the steps are the government is actively contemplating to take a step by directing the Tehsildar. Now, Tehsildar will not be there under the corporation.
Committee.
By involving the respective departments / organizations for demarcation of the plots in terms of the record of rights, and in order with an intent to identify the encroachers so that they may be removed. However, Ms. Patnaik is unable to produce any document in this regard, except the instruction which she received from the responsible officer. Let this matter be listed when.
3 weeks time, everything.
Why 3 weeks?
3 weeks, so that whatever documents, whatever communications can happen, I can
Come on,
put it before the.
give a date.
30th April.
30th. When Ms. Patnaik will furnish the steps having taken, will submit a report regarding the steps having taken as submitted before us.
Item number 10.
This item was listed on 4th of this month along with read petition 5909 of 25. The notice is issued, but the order is not uploaded in this.
There is the file.
Lordship.
What?
If there is another connecting catch is there.
This case 59. No, this is not a 59.
Lordship, this is listed along with 5909. On 4th of April, this is listed along with 5909. In 5909, the order is passed, but in this matter, the order is not. Lordships issued notice on this matter.
Is the same matter that of the another 50?
Mr. Pari?
Yes, probably. It is the same matter.
So we are issuing a notice and then.
Yes, ma'am. Yes.
Fixing it on 25th April.
Publish, ma'am.
There is a direction for affidavit.
Shall be solved.
Within 3 weeks. Within 3 weeks, it will not.
Then it will
2 weeks. Make it a shorter 2 weeks.
2 weeks. Make it
So it will come definitely. 2 weeks 4. Today is the day.
Active 2 weeks is
And 3 weeks will be.
Seventh May. 7th.
Item number 11.
May please.
What? Pan masala. Pan masala.
Pan masala, that business has already gone since 2013. Unfortunately, my lords, on the statement of another person, that my machines were seized. But on the statement of another person, my lord, that he has rented his building to me, they, my lord, slap a demand of around 464 crores.
464 crores.
Without, my lords,
What was your turnover?
nothing, my lords. It was closed since 2013. It was sealed by the excise department. Thereafter, my lord, because of the restrictions, I went for a Sada Masala unit. That did not work. That was also closed in 2015 onwards. Now, my lord, the commissioner, he does not appreciate the fact that the person, my lord, who says that he has rented his building to me, no rent agreements were produced. The packaging units, that's the pan masala which was seized. Your lordship knows, my lord, that there's a pan masala packaging machine capacity determination rules. That particular rule was never adhered to. It was not, my lord, it was only on approximation that they have slapped this demand, my lords. It's confirmed by the Commissioner of Appeals. Now I'm before the CESTAT, my lords. Now the CESTAT, not a limited issue before your lordships today, my lord.
Let's say the statutory deposit.
That, my lords, out of, my lord, the maximum, as your lordship knows, my lord, out of this demand of 464 crores, the maximum which I have to pay is 10 crores, my lords. Because
There's an outer limit.
there's an outer limit, my lords.
Okay.
So 35.
10 crore. How much has been?
My lord, I have already paid 2 crores.
Right.
I made a request to the CESTAT
Extension of time to.
No, to allow me to take the balance. No, not the exam, because that can't be exempted as per the 2014 statute.
That is what I was just.
My lords, that can't be exempted. Permit me to file a bank guarantee for 8 crores because I do not have any business now. I have already paid 2 crores.
Nowadays, the bank guarantee does not,
My lords,
unless you deposit the entire amount.
your lordship would appreciate, my lord. Your lordship would appreciate, my lords. Had it been your tax, my lord, Dunlop would, India would stare at my face. Your lordship knows that this is a pre-deposit. And a pre-deposit which is refundable to me if at all I succeed in the appeal with interest if there's a delay. True, my lord. And the second part,
which is more.
my lord, and the second part, my lord, I should have the wherewithals, my lords. I should have the wherewithals to pay up this 8 crores. My lord. And that particular aspect, my lord, has compelled me to approach your lordship in 226 minutes.
Bank guarantee, because nowadays the bank guarantees are issued
But because I have some
money in the bank account.
Now, my lord, with my credibility,
Those days of 50% or a 40% or a 60% has gone now.
with my credibility, my lords, I need not have to insure the entire amount of 8 crores. So the banks, my lord, are coming forward, my lord, to give me a bank guarantee.
You don't know who.
But
NBFC or what?
I'm not sure the banks.
Then is a public sector, the SBI.
That was my limited prayer before the authorities. Because out of 10 crores, I've already paid 2 crores.
The language is deposit, not secure.
May I just 35
deposit or give a security? What is the amount?
No, section 35F.
35
F of the Central Excise Act.
Central Excise Act.
Page 27, it has been reflected.
It says deposit.
They have retracted.
Deposit.
Not secured.
The language your lordships are correct. It is deposit of certain percentage of duty. But your lordships, may I have a small, humble suggestion. I am fortified by a decision of the Calcutta High Court, Lord. It says that 50%, Lord. And that was not carried to the Supreme Court. And my instructions are, Lord, it was dismissed on the grounds of delay. And in the meantime, since this order of the Calcutta High Court has been worked out.
I was astonished.
Sorry,
reading your prayer.
It's Honorable Justice Mukherjee and Justice Nizamuddin. In 2 cases, I just hand over subject to your lordship's kind consideration. And that was also noticed. And the ground, my lord, which they have rejected.
Sir, if I refer to Supreme Court direct order of the Supreme Court,
no, that is
your prayer. What is that thesis?
No, that decision, I'm sorry, my lord, it was my, that was not a matter which was post 2014. May I just
it may have a persuasive value, but not binding on.
Not binding, but the fact that this particular judgment went up to the Supreme Court.
It has not merged into the Supreme Court.
It has not merged.
It has not.
No, but the Honorable Supreme Court, my lord, while dismissing it on grounds of
on the ground of delay.
Has further observed, my lord, that this 7.5%, which was ordered to be secured by way of a bank guarantee, 50% cash, the other 50% by way of bank guarantee, my lord, has already been complied with, acted upon by the CESTAT, so no further interference.
So that is what I'm saying, because the government or the authorities or the department accepted it.
But so my lord, that will be the persuasive. No, that would be the persuasive.
The department is
no, my lord, that would be the
formidable opponent that's come.
Yeah, my lord, sir, but ultimately, my lord, that would be your lordship would appreciate person not running a business. Measures.
It is statutory.
How can you go? What can this?
And there is no discussion which can be said to be a ratio.
Why I say so?
There is no discussion in that order which can be said to be a ratio of law.
The Honorable Calcutta High Court was discussing appeal. In an appeal, my lord, under the statute, that is 35G, still, my lord, they exercise the jurisdiction of 50-50. I have approached a lordship in a 226 jurisdiction, my lord, with my inability, my lord, to pay this 10 crores.
Then the appeal is guided by a procedural law applicable to the
No, my
court.
lord, but all the same, my lord, their lordships have directed, my lord, for a 50-50%.
I'm telling you, then there is a distinction. When an appeal is filed before the High Court of Calcutta, then it is guided by either a appellate side rules of the Calcutta High Court or the Court of Simplicity. Not to be guided by any other, because it's an appeal under the statutory, special statute.
But they have.
So if a stay is to be granted, the stay is granted by the High Court, exercising the appellate powers emanating from the Court of Simplicity. And the Court of Simplicity, Order 41, Rule 5 and Rule 6, if you look at, it talks about the security to be given. And if it is a security to be given, then either of the board can be adopted. There is no difficulty in that regard. Probably for that reason, the Supreme Court.
No, the Supreme Court, the Supreme Court, not in a very crisp way, they dismissed it on the ground of delay. May I just hand over to
very difficult.
Some laws, 226
When
laws.
it talks about the deposit and 226 or 227, then we have to.
May I just, for my satisfaction.
No difficulty.
A very short judgment note. And they have considered the post amended 35F. This is the first one is of bridge money out. The second one is of perfect technologies. Two independent orders.
There is no
discussion of law.
You can't call out the ratio.
I do not
call out the ratio that we can bind ourselves.
Honorable Supreme Court cannot have concurred to that. Of course, time was a factor. For
We
which
cannot say that. That may not be said that.
I was only approaching. I am approaching a lordship in a 226 jurisdiction. I have not set forth the facts that the business is no more there.
Why don't you work out your remedy?
I tell you, though we find that this particular imposition is harsh,
much.
but you have to accept that.
So at least bank guarantee 50% and other 50% I'll try, my lord.
What is that legal message said lex? Is that?
This,
Younger generations must be knowing that. They Google so
very bad in this Latin phrases. The Honorable Supreme Court, if your lordship would see, this was a 2024 order minutes. 13/8/2024 minutes.
They have bestowed upon the payment of field depositor.
No, because there, in that case, the appeal was dismissed. After the Calcutta High Court
because of non-deposit.
Deposit of non-deposit.
So
And
that's
thereafter,
what-
Lord,
and,
after that, after the Honorable Calcutta's High Court judgment, I would say, they
paid this bank guarantee along with the 50%. And that was also, if the Lordship would kindly permit me, that was taken note of.
I do not know, the condition of pre-deposit of 7.5% of the outstanding dues.
Lordship, if the
That
Lordship
is,
would
that
kindly
is a
turn-
precondition to restore the appeal.
Sorry,
That is a precondition.
no, no. With great respect, Lords, in order to entertain the appeal, I have to pay 10%. 7.5% at the stage of the commissioner, 2.5% Lord, at the, if I go up in further appeal before the tribunal. So this is the 10% pre-deposit of the amount with an outer limit of 10 crores. So since of the duty demanded. So since Lord, for a moment, Lord, the Sestat Lord has considered this. They say, Lord, they are not applying the Calcutta ratio because I have not paid up that 50%. Your Lordship will kindly turn to page 20, paragraph 10. I'll only try to persuade your Lordship. Page 28, my Lords.
Which one?
Page 28 of the, running page 28 of the brief, my Lord. That's the part of the ordinance. Paragraph 10. Lordship, are with me? Your Lordship are with me, page 28, paragraph 10. The decision cited by the learned counsel for the applicant in case of Bridge Kishore Manias has been passed by the Honorable High Court in the facts and circumstances of that case. And in that too, the Honorable High Court has directed the appellant to make a deposit of 50% of the amount representing 7.5% of the total tax effect in cash and the balance by way of bank guarantee. Whereas in this case, it is not so, as the applicant is seeking dispensation of the mandatory pre-deposit of 8 crores out of 10 crores, which works out to 80% of the total mandatory pre-deposit. So, my Lords, they are with me so far as the High Court's Honorable Calcutta High Court's decision is concerned, but they drive me out because I have paid for 80% of bank guarantee. Now, I am prepared, my Lord, to pay this 50% of the 8 crores, my Lord, in bank guarantee.
And para 11, we are bound by the law, and therefore the miscellaneous application filed by the applicant has no merit and dismiss. And
no,
we
merit. These are the preconditions. These are the preconditions to maintain the. These are the because of the fiscal statute, they have to. So what they say is that we could arrange only 2 crores, we deposited. We are further arranging 3 more crores, and then we'll pay for 50% back in the said order. What is your reaction if they pay 3 crores pay within a very short time?
And let me take instruction on this matter.
You take instruction and come back, no difficulty. If that is there, we persuade him.
My government friend is fair enough because he knows.
That's why I say persuade him. He agrees, no difficulty.
Let us pray for next week if possible. Subject to lot.
When?
10 days.
10 days or you have to take instruction.
Actually, also we are giving the matter to the law department, and the law department can take concern with the concerned department in take time. That's the only solution.
We can give you.
I'll try my level best, Lord. See, within a short
We can
period.
give you a week's time. We can list this matter on 24.
Then I will give in the meantime what my appeal may not be dismissed.
Appeal is no more.
No, appeal is there. Appeal is still surviving.
So tell him not to pass any order.
Due apology, my lord. There is an urgent matter which your lordship's endorsement from 9th. It was with the concerned honorable judge, my lord. Single judge is concerned. They are the assigned bench. That's why the file is come before this and your lordship for endorsement to any other bench. And the last date is the eviction matter, my lord. Anytime.
It's already done, madam.
My lord, that is not done.
I assure you that I do not keep any file.
That's not placed before your lordship.
In the night I sign everything.
That's not placed before your lordship. That's what I'm saying.
So we'll.
On 9th it has come. My lord. I went to DR thrice and it is.
Item number 12.
Item 12 and I think now one is after. Madam?
You want 1B?
One is.
Committee under the chairmanship of the assistant executive engineer has been constituted to inquire into the matter. That is my instruction. That is an order. If my learned friend wants it matter to come after 1 week, then Lordship may keep it to after 1.
Additional affidavit you have not filed.
My lord, it is filed, my lord.
When?
7/4/2025.
At flag A.
My
What is their good name, sir?
Subhash Chandra Mishra.
Your power in this case?
My lord.
Mr. Mishra, learned counsel for the petitioner, prays for an adjournment. Put up this matter.
23rd May.
3rd May 2025. Sorry. 23rd April 2025.
Item 13.
Last order, your Lordship, 3/4/25, your Lordship is directed to take instruction regarding this. Misuse of the Gocher land by the Finance Authority. Reservation portion of land. Construction has been stopped. Whatever construction was carried out has been stopped by the order of the Tahsildar.
The nature of the land has not been converted.
No, the de-reservation proceeding has been initiated already, your Lordship. That is my instruction. My Lord, construction is going on. No, it has already been stopped. This is the instruction given by the Tahsildar.
Produce the evidence that if they are saying on this, then we have to produce an evidence.
What is page 3 of that instruction?
Here.
First para. As per the provisions of the UGLS Act, though some of the land is Gocher, the Tahsildar Bhadrak has started a de-reservation by case number so and so arising out of alienation case number so and so to effect of excess Gocher land of the village, and the same is under due process. In the meantime, the Tahsildar Bhadrak has got the information about construction of the land, and instantly the construction work has been stopped and directed to no construction work till finalization of the alienation.
So you have already initiated a alienation case.
Yes.
You can go and intervene in that.
Initially, the alienation case was initiated.
What is this alienation case? What for?
The land has to be alienated in favor, either it is government or a private party. The land has to be alienated in favor of that person, so that a construction or for whatever purpose they want, a settlement has to be done.
I do not know what is the system here. I am groomed in a system which is different.
Yes.
Suppose the record of right shows the nature of a particular land.
Yes.
If it is a Gocher land, that means for the grazing of the cows.
Yes.
It cannot be used for any other purposes. It cannot be used for homestead.
Yes.
I do not know. There must be a provision in the State Act
under the OPL
that
Act.
if you want to change the character of a land from a Gocher to a homestead or anything else, then in that event a proceeding has to be initiated.
Yes.
That proceeding has been initiated. Order has to be passed by a competent authority that the nature of the land has not changed. And then thereafter, the permission. If somebody without changing the nature of the land made any construction, then it is not only the civil offense, but also a criminal offense there in the West Bengal. 3 years.
Here,
3 years.
Here, admittedly, construction was carried out.
But Mr. Das, you cannot initiate both the proceeding simultaneously.
No, my lord, alienation proceeding was initially initiated. Subsequently, pursuant to the order of the Tahsildar, a de-reservation proceeding has been initiated. After closure of the de-reservation proceeding, then
Then
the
alienation
alienation will
proceeding
be
will
done
proceed.
and then
If
thereafter.
it is de-reserved, then only alienation proceeding can
So
be.
there must be a de-reservation proceeding.
Yes, ma'am.
Then everybody who has got an objection has a right to.
Yes,
to be heard.
ma'am.
You can go and intervene in that. We are directing them to give you all the details.
Case number de-reservation, case number maybe supply alerts.
Yes.
4 of 2020.
Unnecessarily, we will not keep this part of the deal. And they have already taken steps to stop. And if you find that the statement is absolutely incorrect, then you can definitely approach the court and you can then hand this Tehsildar Bhadrak liable why he has said so.
Yes, so Lordship will have a plans to.
Because the prayer is the nature of solely directing the collector to conduct an inquiry. However, this use of this would not to change the nature. So we have already started actually new going. Yes. The opportunity, the nature of a public interest litigation is at the behest of the petitioner alleging the unauthorized and unlawful. Double negative makes a positive. If you have said unauthorized and unlawful misuse or use. Unlawful use.
Unlawful use.
Use of the Gocher land pertaining to the Khata number 687 from a plot number 2083 in Gelpur village under Bhadrak Tehsil. With further prayer, in relation to the changing the nature and character and then changing the nature of the reserved Gocher land without following the due process of law. It is like next one. It is pleaded in the said application that the Gocher land, which is recorded in the record of right, is unlawfully and unauthorizedly used by certain section of the squatters for other purpose for which it was so recorded. On the last occasion, we invited the attention of the state in this regard, and the matter was adjourned to enable the learned additional government advocate to take necessary instructions. The Mr. Das, the learned additional government advocate, hands over the instruction duly signed by the Tehsildar Bhadrak, dated 16/4/2025, indicating that the construction work which was undertaken at the said land has been stopped and now stopped with further direction not to make any construction work till the finalization of the alienation process. It is further disclosed that a proceeding that is de-reservation, the proceeding for proceeding of de-reservation, we take case number 4 of 2025, arising out of an alienation case number 5 of 2025, has already been initiated and the same is under process. It is beyond a cable of doubt that the moment the nature of the land is recorded in the record of rights, the provisions contained in OGLS Act does not permit the conversion of the utilization of the land for the other purpose, unless a proceeding is initiated and an order is passed by the competent authority. Precisely for such reason, the dereservation case, along with the alienation case, has been initiated. And the competent authority will take a conscious decision thereupon. There is no fetter on the part of the petitioner to intervene in the said proceeding, to ventilate their grievance in relation to a conversion of the land to be utilized for other purposes, and the authority shall take note of the same while passing a final decision in the said proceeding. Since the primary grievance raised in the instant public interest litigation has been addressed by the authorities, we do not find any justification in keeping the instant proceeding pending before this court. Accordingly, the instant writ petition is disposed of. It is open to the petitioner to approach the competent authority before whom the aforesaid proceedings have been initiated and pending, and ventilate all the grievance either raised in the instant public interest litigation or available in law to be decided on its merit.
May I submit, madam? Section 4, objection raised by these petitioners. They may be admitted both sides, they may be heard in both sides.
Yes, that's true. Let's say
They have
it goes without saying
without
that,
notice,
that
without notice.
the competent authority shall follow
Without notice.
the principle of natural justice before it takes a final decision.
They may, there may be opportunity of hearing both sides.
Natural justice means what? One liner is sufficient.
They can respond to the proclamation that is already.
Item number 14.
Yeah, please, Your Lordship. My lord, the petitioner is a contractor and he has been awarded and work as per Annexure 1. And the work has been already completed. So in the previous occasion, state was to obtain instruction regarding the pending payment.
That is the status of the final bill.
The work was completed in 2017. From 17 till 2022, no claim was raised before the authorities. And
you are a state. I understand where you are heading. You are a state too.
No, my lord.
You are not supposed to take a plea of limitation.
But the instruction which I have received, the instruction which I have put that
the state cannot.
Received, but the executive engineer who was in the charge of this affair, this construction, and a vigilance proceeding has been initiated against him for the period 2017-18, 18-19, and 2020. And all the records have been sent to the vigilance authorities. So,
central vigilance or the state?
State vigilance. This is the instruction which I have received from the superintending engineer.
Now the madam will have to. They have been served with the notice.
That was not there.
If you just initiate a proceeding and keep that particular notices and everything in your drawer, then it is not a proceeding at all.
Sorry, I have not made photocopy.
The police, why the police?
Well, they have sent all the records because they are inquiring, the vigilance authorities are inquiring. The next page.
Have you lost an FIR or something? Why the investigation
That
by the
specific
police?
instruction is not with me. They have not provided to that extent.
Okay.
The instruction is vague. Nothing, no details is there.
They have enclosed the document, the page thereafter.
So why the police will make an inquiry? Superintendent of police.
Superintendent of police has.
That means you have gone and lost an FIR or a complaint against them.
No, my lord, superintendent of police, she has implemented as party, my lord. Superintendent of police has given the instruction that the records has been sent to the vigilance for inquiry with respect to that alleged irregularity or illegality committed by the ex-executive engineer.
Sir, have you seen the earlier?
What the letter says is different. This has been handed over to the superintendent of police. It has been handed over to the superintendent of police.
You handed over.
Yes.
Vigilance HON'BLE.
Yes, that has been. Yes, that has.
So why superintendent of police will intervene? It's your internal matter. If they have committed any violation of the contract, or they have raised, I would say, the fictitious bills for the work which they never undertook, I can appreciate you will take a decision. Why FIR? Any fraud, forgery of any kind committed by him?
Not by him, but by the executive engineer who was in charge and who under whose supervision the work was being executed. Against him, the vigilance authorities have been.
If they have executed a work, then in that event, either you'll have to appoint another engineer who will go and verify that the works are done according to the specifications given in the order, purchase order or work order. Everything has to be seen by you, and you can't withhold the money.
I'll have to take specific instruction on this.
Steps against the
Grant me a week's time. I'll take specific instruction on this.
What I want.
That's sure.
May I submit something?
Make an inquiry through an independent engineer for the work done. What was the work contract?
That it was under Rukura
No, what was the any construction work or something?
outlet gates under Canal Division Rolkala. That fabrication erection of number of outlet gates.
Okay.
And my lord, the work has
Go
been.
and see whether those have been constructed or not as per the specification.
And kindly
and Annexure 4.
Annexure 4, my lord.
Yes, that's what.
It has been transferred to OP2. It has been, that work has been awarded by executive engineer, but it has been transferred to OP2, my lord. That is under Annexure.
Last occasion also you are directed to take instruction on Annexure 4. Diverted.
Somebody else?
It has been transferred to OP2, my lord. That is under Annexure 4 series.
Cancelling your contract.
No, my lord, that work. Well, I kindly have a glance to Annexure 4.
Administrative control was transferred.
Yes, my lord. Under second para, all your documents received under your reference forwarded to the chief engineer and basin manager, Brahman Basin, for taking necessary action. Who is OP2, my lord. It's not there under executive engineer anymore.
No, that's true. It has been, the administrative control has gone to CE and BM.
Yes, my lord.
This Brahmani Basin.
Since 2022, and in second para, it has been mentioned that it is forwarded to the chief engineer and basin manager, who is OP2, my lord.
So you'll have to take instruction.
I'll take instruction.
You have been specifically directed last occasion also to take instruction on Annexure 4. Now you are taking some other plea. You are taking some other plea.
Issues, very fringe issues, small issues. When?
A week's time may be granted.
Mr. Das Leonard, Additional Commander Advocate, prays for further adjournment to take instruction in terms of order dated 25/3/2025. Prays for a week's time. Next time to put up this matter on 24th April 2025. Instruction, if any, shall be obtained in the meantime positive.
Item number 15.
Make. And for petitioner. This is the last order. Yes. Regarding fixation of seniority, correction of seniority list merit. Just now in the launch hour, they have served the copy of the counter. This is the last order. On the interim, IA also they had taken time to. I will file the reason of my lord. That at least interim order, any promotion to the post of headmaster subject to result of the case. Because
No interim order, sir.
no, interim order, IA notice was issued on IA, my lord.
No, notice has
I
been
pray
issued.
for interim order now. I pray for an interim order.
What interim order? It is the intercession of seniority.
Seniority. We are before finalization seniority, they are trying to promote the senior post to the post of head clerk.
Seniority has been assigned as per the provisions contained under the rules. So I can argue, if my lords allowed me, I can argue on merit that it is as per the rules, the seniority has been framed, has been fixed. So, interim order, if subsequent.
That's what we are asking.
I have received the confirmation in the merit list, my lord.
Then you have received the count.
Yes.
You file a rejoin.
I will file the reason of my lord.
Without any interim order since 20th March.
Mr. Malik, learned counsel for the petitioner, submits that he received the copy of the counter affidavit in court today and prays for a short adjournment to take instruction on this step. Put up on name.
Short more or short that, my lord. I can within a week.
5th May 2025. 25. Instruction, if any, shall be obtained. Sorry, counter affidavit. Filed by
this OP number 1 and 2.
Opposite party number 1 and 2. We brought on record in the meantime.
Item 16.
I will file the reason within a week. And in the meantime, any promotion to the post of head clerk will be subject to result of the case.
Not worry.
Item number 16.
Item 16, my lord.
Yes.
May I audible, my lord?
Yes,
May I audible?
Sir, you are audible.
Yes. My lord, last occasion, my lord directed to obtain instruction. We have received the instruction, but it is not readable. Let me give more time because that copy which has served on the office of DSJ by note sheet, this written by I think this any of the officials have noted it, but it is not, neither the lordship can read it, I can read. So I need some more time to get the further copy of this.
A poor workman and you are legally.
Well, they have noted, but I have not read the note sheet. But the instruction I can read, my lord. They have written that it is emitted that the complaint dated 8/9/2022 filed by the
Only that much. The order has not yet been implemented. He approached the Labour Commissioner.
It was failed. Ultimately, they have written it. The conciliation proceedings is failed.
So, why don't you say that? Yes, it has failed, sir.
Yes, they have written it. This conciliation was held on various
the very day your lordships heard this matter on 19/3, during at 8 p.m. by email they sent that conciliation is a failure, but till that they have not referred the matter to CJ.
When the conciliation failed?
I only my
Mr.
petition.
Mr. Namba, please tell us when the conciliation failed. What is the date of failure of the conciliation?
On 19/3, 8 p.m. only.
19/3 the conciliation failed. Then what is the procedure, sir? It will go.
Failure report he has to submit
to the appropriate government. It will go. So your complaint has been taken care of.
Taken care of.
So what remains in the petition?
No. Now it remains not. Because I had come for appearance, no objection certificate was not issued to me, for which I couldn't sit in the exam, appear the exam. It was the case, main case. But your lordship was pleased to iterate whether Annexure 5 has been mitigated by the authority or not, Deputy Labor Commissioner Central. And now, on that very evening, they sent that your
For our instruction, it was valid on 10/2/2025.
Now, alleging the same, alleging the prayer made in the writ petition, you have moved the Chief Labor Commissioner. So that conciliation has failed. Now it will be adjudicated.
As per law.
Yes.
Yes.
Whether the domestic inquiry was proper or not, whatever. That will be adjudicated. So what remains?
It remains nothing since your lordship gone. But sorry to say that on that very night I received this message. That it is failure.
This writ petition has been filed with the following prayer. Step. Making the allegation made in the writ petition, the petitioner, workman had moved the Chief Labor Commissioner, Bhubaneswar, by filing a complaint. Step. He, being the conciliation officer for the state, took up the proceedings, conciliation proceeding. Step. It is informed to the court that the conciliation has failed and failure report will be submitted to the appropriate government shortly. Step. Mr. Parhi, Leonard DSGI, submits that the failure report has already been submitted or not.
It is not there, but they have said that it was failure on 10/2/2025.
So, submits that conciliation, conciliation
was held on finally on 10/2/2025.
Dated 10/2/2025 has already been communicated to the petitioner. Step. And steps are being taken to refer the matter to the appropriate government. Step. In view of the above, this court expects that the failure report should be submitted to the appropriate government within 2 weeks hence for taking necessary action to refer the matter to an industrial adjudicator. Since the matter has already been taken cognizance of by the Chief Labor Commissioner and failure report has already been submitted, there is no purpose in keeping the writ petition pending before this court. Step. With the aforesaid observation, the writ petition is disposed of accordingly.
Item number 17.
May I pray, my lord, this instruction which I received, my lord friend, is there kept on record? It's better, man, because we are not filing the affidavit there, sir. Mr. Sir. So Behra will provide it the same because we have received the instruction.
Mr. Behra, Leonard CGC, you are CGC?
Yes, he is CGC.
Mr. Behra, Leonard CGC places on record the written instruction received by Leonard DSGI, which is taken on record.
Item 17.
Item 17. I claim your lordship may take up this letter on 29. In the meantime, I will file comment. Today I have received the provided reply.
Mr. Das, Leonard Additional Government Advocate, submits that he has received instruction in the matter and will be filing the counter affidavit by 29th April 2025. Let the counter affidavit be filed by 29th April 2025, serving copy thereof on Mr. Vishwal and counsel for the petitioner. Put up on
7th May.
7th May 2025.
Interim order.
Interim order is there?
Yes, madam. On 20 on 3 to.
Sure. Interim order dated 20th March 2025. 21st March 2025, passed in IA number 4146 of 2000.
Mr. Vikas is suffering from high fever. Kindly adjourn this matter next week.
Have you filed your Vakalatna,
No,
Mr. Sarma?
I have received instruction yesterday. I'll be filing Vakalatna for OP number 125, and I pray 3 weeks granted to file counter affidavit. Even though Lordship had they had served a copy or not, Lordship has issued notice on admission or not, that also I don't know. Only by seeing the record, I am submitting this.
You have not received the copy of
No, your Lordship on last occasion, if Lordship sees last order, a copy of the petitioner served on counsel for the MCL. I have received instruction yesterday. I am appearing today. I'll file Vakalatna for OP number 125.
You have not received instruction on the writ petition. Mr. Sarma, learned counsel, submits that he has instructions to appear on behalf of opposite party number 5. 125, and undertakes to file Vakalatnama on their behalf within
1 week.
Within 1 week. Step, learned counsel for the petitioner prays for an adjournment, submitting that learned senior advocate is in difficulty. Step, put up this matter on
7th May.
7th May counter affidavit however. Next
14th May.
14th May 2025. Counter affidavit, if any, shall be filed in the meantime along with the Vakalatna.
Item 19.
Opposite part number 125.
It legal also. My lord, I may be permitted to place the order dated 25/3/2025.
Yes, Mr. Misra.
My lord. I am reading, my lord. The matter is taken up through, I don't know, Mr. Sundarai, learned counsel submits that Mr. Suna Sahu, learned counsel has instruction to appear on behalf of the opposite party's Indian Bank. Petitioner in the writ petition seeks to assert the letter dated 10th March 2025 issued by authorized officer Indian Bank under Annexure 6, cancelling the sale in favor of the petitioner in respect of flat number 301, Block B, Sibhanath Lifestyle, Sahidnagar, Bhubaneswar. The petitioner also assails the fresh auction sale notice dated 11th March 2025 issued by Indian Bank under Annexure 7 for the aforesaid secured asset. Mr. Misal, on account of the petitioner, submits that he is the auction purchaser of the secured asset and has deposited 25% of the sale price within the stipulated time. As the property was seized by Enforcement Directorate, the petitioner, by letter dated 15th September 2022, Annexure 5 series, requested the authorized officer Indian Bank for extension of time to deposit the balance 75% of the sale price till issuance of the letter of cancellation by Annexure 6. No communication was made to the petitioner in respect of his request for extension of time. Mr. Misal, on account of the petitioner, relied upon the case of IDBI Bank Limited versus Ramswarup Dalia and others in SLP number 8159-8160/2023, disposed of on 16th October 2024, wherein the
come to para 8.
My lord, I have filed, my lord.
You have filed your petition.
My lord.
Have you taken a decision within 7 days?
What we have instructed that they have the judgment of IDBI versus so para number 8, which is I'm just submitting here. There is no dispute in the fact that the Upland Bank has issued e-auction notice at Saptar Singh and had conducted the auction loss charge the respondents had participated in the said auction and were recognized as the highest bidder who deposited 25% of the auction.
These are all the
just amounting to 36 lakhs then and there. As per the rule of the security interest, section 9(3), it clearly says that on every sale of immovable property, the purchasers are immediately on the same day or not later than next working day. And the auction was held. And
kindly glance. No, please come to paragraph 11. The Lordship has already said that yes, you can proceed with the auction, but you will not take any final decision.
No, madam.
So, auction you must have conducted.
Yes, madam.
Final decision you can't take. The question was that he made a representation. He was permitted to make a representation and you were directed to take a decision on the representation. Have you taken? He says that I submitted. Have you taken a decision within 70? Why?
Why?
Why you have not taken?
Because my lord, as because my lord, the representation, the bank authorities have not intimated that the representation has, they have not.
He has said that representation is made in terms of the order.
They have received it under seal and signature. ठीक है, এটা kindly ठीक है. ठीक है. Under seal and signature they have received. I'm giving a copy to him. 27th your lordship directed, 27th under the seal and signature they have received. Yeah. It is received.
There is a seal and where is the signature?
Where is the seal and signature?
Against it, your lordship, that is not.
No, this paragraph says received, only signature. Where is the seal?
Yes, your lordship, that is not visible in the Xerox. ठीक है. Sorry.
Okay. Why it will not be visible? If you make a darker one, it will come.
That is your lordship somehow. But it is received, yes. That is received.
Yes.
Yes, sir. Show it to him.
Yes, ma'am.
I have given a copy. I have given a copy.
No, the seal is not visible. Look at it. Just show it to him. Show it to him.
ठीक है. Yeah.
On 27th March.
But the seal is there, sir.
Yes, ma'am.
So,
Due to all of my senior minor, I had my senior.
Where is Mr. Sahu?
He come through himself on my group. So that
Last occasion also he was not there.
he informed me to receive the notice, notice. But
You are Mr. Sundarai. So last occasion you are there.
but my senior is today he is online.
Okay. Mr. Mr. Learned Counsel for the petitioner submits that pursuant to the direction of this court dated 25/3/2025, the petitioner submitted the representation on 27th March 2025, which was issued by the bank with seal and signature.
My lord, my senior placing this phrase auction dated 11/3/2025 is already been failed, my lord, as because no one is participating in this order bid. So that will this auction is failed, my lord.
Then your lordship, as per that may be allowed.
Concerned with the auction.
Then my lord may.
Even if you have conducted the auction, final decision was you cannot make. But your obligation to consider the representation that remain with you.
Then my humble
Whether
prayer, my
bidder
lord.
or no bidder.
Then my humble prayer, my lord, since basing on the judgment of Honorable Supreme Court, your lordship said to consider and I am ready to deposit 75%. That is what the Honorable Supreme Court has said. I'll deposit within 4 weeks. Your lordship may direct them to.
So let them take a decision on your representation.
Let them. I am since he is saying that the fresh auction has been cancelled. And I am ready to deposit 75% as per the judgment of Honorable Supreme Court.
It is possible, my lord. As per the security interest rule, section 9 rule 3 says that on every sale of movable property, the proceeding can deposit the 25% on the same day or not.
25%.
25%.
25% you have deposited.
Yes.
They are not depositing the 25% on the same day.
No,
Well,
that-
They are not depositing the 25%. So that's why
They are not depositing means they have already deposited.
deposited as after our intimation is there. That's why.
What intimation? That you deposit the money?
No,
Yes.
kindly take the answer to me.
Mr. Sundar Rai. You decide the representation and come back. We'll see. The
Similar take time 25%.
Are Baba,
If you argue, then the question would be that this security interest rules, whether these words are mandatory in character or a directory in nature. If we say it's a directory in nature, then where you will stand?
You follow?
It's our mistake on that. That's right.
Statute says a certain things to be done. Then in order to interpret this statute, the one must look into whether it is of a mandatory character or a directory character. If it is of a directory character, then there is no difficulty in extending the time. The court can. Then if we say it is directory, then where do you stand? Just imagine. No, we have not applied our money.
On our side, we have taken. So this is the.
Maybe. That's your purpose.
In a
adversarial system, you have one person, they have another version. We are here to see that whose version is correct. If we accept their version that it is directly, then where do you stand? Tell me.
If the fact is disputed, so my lord, section 17 gets.
So you are not following what the court is saying. Please try to follow the court at least.
Your lordship, may direct that, let them to. I understand. Not I understand. Let them take a decision. I understand, your lordship.
It is submitted by Mr. Sundar Rai, learned counsel for the Mr. Sundar Rai, appearing on behalf of Mr. Sahul, learned counsel for the bank, that the representation has not yet been disposed of. Hence, the matter stands adjourned to be listed on
6th May.
6th May 2025. By that date, the Mr. Sahul, learned counsel for the bank, circulation record the decision taken by the bank on the representation submitted by the petitioner on 27th March 2025.
Interim order may continue.
Interim order to continue till next. Such and such.
Item 20.
Again, your lordship, that is a similar matter. Here also, reference on, I have filed on 27, that similar matter. Item 20.
Same thing.
Similar matter. The same order, I have filed the reference on 27th. Same.
Item 21.
No, it's not a mistake. We have not committed any mistake.
21.
And that's item 21. On behalf of Mr. Palit, Senior Counsel, I pray for a week's time. My lord is currently unwell.
You are appearing for
the petition.
The petitioner. Who is the senior counsel?
My lord is unwell. Mr. Palit is unwell.
Oh. What is your good name, sir?
Shritam Mahanti.
Shritam Das Mahanti. Mr. Mahanti, learned counsel for the petitioner, prays for an adjournment, submitting that Mr. Palit, learned senior advocate, is indisposed of. Sir. Hence the matter stands adjourned to be listed. When do you want?
Let's delegate next.
6th May 2025.
And appealing for 1 into I'm appealing for 1 into
1 and 2.
Yes.
You have filed your appearance.
Just now.
Don't. Record.
Item 22.
May I please, your lordship, my lord. On our last occasion, direct to take instruction, my lord, regarding the constitute of Arai Circle, Kusura.
At the locality Bograi district, Chanaka Mela was going on and all the officials were busy with that. 7 days. Yes, my lords. It is a big famous Mela, 7 days time, my lords. And the instructions. Except for 7 days, my lords only.
Ms. Das, learned additional standing counsel, prays for further adjournment to obtain instruction. Put up on
24th.
24th April. Will it be all right?
Yes, ma'am.
24th April 2020.
Item 23.
Item number 23, Mr. SP Mr. Seniority appears. He had undergone a surgery and yesterday his stitches have been open and doctor has advised for 10 days complete bed rest. Otherwise he could have done it through hybrid mode. I had been to his office yesterday. So he has instructed to make a prayer for 10 days only so that my senior can appear because it's a mind's matter. Otherwise they would not have known madam and I could have also.
As prayed for by Mr. Samantarai, learned counsel for the petitioner, put up this matter on
30th April.
30th April. 30th April will be all right.
Yes, Mr.
Item 24.
Also the 13th April.
30th April.
30th April.
30th
24 May, please.
24.
Miles. Last occasion. Ordered 3/4/125 penalty. The honorable lordship has directed to file the detailed advertisement. I have complied. That's order, my lordship.
Detailed or notice.
My lordship.
That notice my learned friend has produced by way of a memo before the honorable court. I have requested him to file it by way of an affidavit because it is a very voluminous document so that I can respond along with the counter affidavit and everything.
By affidavit. Do you disbelieve Mr. Das?
No, I don't disbelieve, but
This is your document.
Document is yours.
Is it served on you? A copy of this is served on you.
Just now he served on.
So why affidavit? It is served on you. If you want to respond to that, respond to it.
Your document.
Your document.
Would be hyper technical.
Yes. Do you want to respond to it?
We will file the counter affidavit for lordship by grantors.
Mr.
Notice has. My lordship, notice has not been soft.
We have not applied mine. Mr. Das, learned additional comment advocate, prays for an adjournment to file, to take instruction and file counter affidavit. Put up one. When can you file, Mr.? 2 weeks time.
5th May.
5th May 2025. Counter affidavit, if any, shall be filed in the meantime, serving copy thereof on Mr. Das, learned counsel for the petitioner.
Item 25.
In this case, from the department side, I have to take instruction. I have already sent the instruction and they need another 1 week to give me the details of the instructions. With 10 days time.
The faceless assessment and then
they have to make a necessary correction. They have sent to the faceless department. So
Mr. Kedia Leonard, you are
Junior standing counsel.
junior standing counsel. I thought Mr. Kedia Leonard, counsel appearing. Not appearing. Tell your department to. Additional. Okay, junior standing counsel for the department raised for further adjournment. When can you?
And
You have not been controlled as senior counsel. That's why you are. Yes.
Yes.
29th April.
29th April 2025.
Item number 26.
26, let's preparing amendment petition. But I have decided to order the rejection to file a better application, Lordship, because that it is not in detail, Lordship pointed last occasion, because all the rules have been quoted, but we have not given the specific reasons for which we have in public and litigation.
The instant petition contains a matter detail which is incurable and pays for withdrawal of the same, the liberty to file a fresh on the same cause of action.
Item 20.
Considering the counsel for the state does not raise any objection to it. On the basis of such submission, the writ petition is dismissed as withdrawn with liberty to file a fresh for the self-same review.
On a lighter note, my lord, on a lighter note, in the body of the petition, he has stated something in favor of the government.
No, I am always with government. I'm never.
Because we are formalities were followed.
Yeah, but we are the government.
Yes, because government is for the people, of the people, and by the people.
Lordship.
We are not, giving a spelling for that.
Item number 27.
Yes.
Impending order under annexure one is an expiry order. My lord have already 27. My lord have already passed the similar case.
Covered case.
Covered case, one thing is different that
It's an expiry.
in this order.
Show it to him. Show it to his,
Here
make
the
necessary corrections and show it to him.
we'll make it.
Yes.
28.
Metro, before my lord is Mr. Naik was arguing the matter.
Pardon?
Mr. Naik was arguing the matter before yours.
This matter?
Yes.
It is coming for the first time.
Now, this is first time seeking liberty from my lords. He has filed in writ petition, and that is how it is before lords.
Oh, earlier writ petition was filed.
Twice they filed, they withdrawn, file. First time they withdraw, again file. Second time they filed, again withdraw. And it is the third time this comes to
with permission also.
I am not stand on the way. You can advance your case to the
The facts involved in this is I had qualified in the
technical bid as well as the financial bid. But that was cancelled and a new bid came up, which is under challenge now. Because in that other person who was also qualified in the financial technical bid as a financial bid, his was rejected in view of this Government of India circular regarding payment of service tax. Service charges. Service charges.
How many bidders were there?
2 bidders.
So single bid.
It was not technically single bid. He had qualified in both.
Maybe ultimately it must to be a single bid.
That was in the RA process, your lordship, that one can always change his rates. Putting after
The position would have been different. And not that particular bid be cancelled for want of any documents.
They have not intimated why it is cancelled. Just it is cancelled in the uploaded in the website. They have come up with a fresh tender. That is the issue.
Show us any judgment that they cannot do it.
Single bid or
no, Supreme Court judgment, because what is playing in my mind is some of the judgments of the Supreme Court which says that there is no difficulty on the part of the authority to cancel it.
At any time.
No, at any time, no. It is after something has already been done and a right has accrued, then cannot. But they are within their competence to do it.
2014 SEC 731 that says, once either participates in good faith and cross stages like technical and financial bid opening, they have a legitimate expectation of fair treatment. That is how they have ended.
Fair treatment, no doubt.
There they don't say that they can't do it.
No, the question is the cancellation, because the question is not unfair treatment. The question is cancellation. Can they cancel or they cannot cancel?
I say, my lord, I say, my lord, rather I would like to say something that this cancellation per se is not a innocuous, my lord. Because the other person did not qualify in the financial bid, in order to accommodate him, this tender was cancelled.
So you are releasing malafide?
Malafide.
Malice.
Have you pleaded?
May I submit
extensively? Because you are putting up a case of a malice.
Malice.
Then you will have to expressly plead that.
My lord, paragraph 14 I have stated that the action of the opposite parties, which seems that in order to accommodate, facilitate somebody, they have cancelled the tender.
This will not do.
This will not.
Some kind of a.
My lord, the other person is not before me because second tender had not come. So I can't now say that whether he is to be accommodated. But question is, his is cancelled, no doubt. Along with that, the entire tender process goes.
That also proves that this particular notion is not correct, because he did not participate in the second.
I don't know whether he is participated or not. Today is the tender opening.
So how can you say that there was malice?
Because my cancellation was in order to accommodate, because he could not qualify. So let us cancel it from the initiation. Then we'll see later on.
You said that to accommodate.
What else? What other language I can use, your lordship? I am alleging against the state authority. I have to have my own restrictions.
And you have not named the person also.
I can't name it.
When you are alleging malice, you can. You have to. That it must be specific.
My lord, I don't know that who is he, but there is a he.
You want the court to make a roving inquiry?
No, let them respond. Why did they cancel? There has to be reasonable basis to cancel.
So,
technical bid I have qualified. There is no doubt. Financial bid was open. And there is a Government of India circular that no, you have to give the service charges unless it is there. Minimum is 3 rupees 85 paisa. You cannot qualify. I had quoted 389. He had quoted 330. And in the reverse auction, my lord, he had given also more. He had offered more. So these are the issues involved. Still, then they cancelled it.
So if it is a reverse auction, then the price bid will be opened first.
No, technically qualified, unless I am technically qualified, price bid has to become. Technically one is.
In a reverse auction, first of all, price bid is open, then who qualify, their technical bids will be opened or.
It's a good question, my lord.
Yes.
Yes, my lord.
For you.
Let's see for a moment page 20.
Page
20.
20. Okay.
20. In page 20, let's see the column 11.
Column
11, my lord.
11.
Yes.
Solvency certificate. of
Solvency
10 lakh or
certificate
above.
rupees 10 lakhs or above from the Tahsildar, Municipal Commissioner, Sub-Collector. What he didn't give.
How
He has given a solvency
Tahsildar-
certificate.
How the Tahsildar will give us solvency certificate?
Here this Tahsildar will give in the solvency certificate. by law.
How?
They assess the value of the land and all these things. Thereafter, Sub-Collector will issue the sub.
Solvency may be not on the basis of a immovable property. It may be on the basis of something else.
But this tender condition is that either Tahsildar or Municipal Commissioner or Sub-Collector.
How
Those
can
the
they-
three authorities
a
are
person-
there.
A person, suppose a person has say 50 lakhs of rupees in his bank account.
My lord.
The more solvency he can show. Then whether Tahsildar will give a certificate.
No, Tahsildar can't give.
Yes, sir.
Yes, my lord. My lord, this tender condition is such. He has not fulfilled the tender condition. He has solvency certificate issued, which was issued by the bank. What is there? On that ground, we have rejected the same. He is L2. According to earlier restriction instruction, I am submitting the same because this it is a listed past time. I could not receive the instruction.
No. He says that his technical bid was open. Everything was in order. Then the financial bid was also open. And thereafter, you unilaterally cancelled the entire tender process.
It is completely wrong, my lord. It is not correct. Why, my lord? On scrutiny, it was found that he has given solvency certificate not from the competent authority what mentioned in the tender condition. So it was rejected. Then it is found that L1 also not competent to do so. So enter procedure cancelled. Now we go for protest. He can
Both the tenderers were disqualified.
Yes. Now we are protective press tender. He can participate. Nobody can obstruct him to participate now.
Page 36 of my lord.
Page
36. And except 4 series.
Sorry.
My lord finds that.
Yes.
First is front line. That was the other person, my lord.
No. What he says is
No. That is absolutely wrong.
What he says is that in the tender document, it says that the solvency certificate must be issued by an authority.
Such and such authority. It is true. I
And
have
it
a bank
says that
certificate.
you did not submit that solvency certificate issued by them.
Yes,
you submitted it, but issued by somebody else.
Somebody by the bank.
So it is not in conformity with the conditions of the
So
tender.
with that disqualification, I could not have qualified in the technical bid.
No, that is not required, sir.
No.
Solvency comes when it's a financial bid.
Financial
And
bid
it
is
is
open.
always first the technical bid is open.
It is part of
Find
the
whether
technical one.
you are technically sound or not, and then the financial bid will open.
I am sorry to differ, my lord.
Considering
It is always the technical part first.
No.
That is what I am saying.
Whether technically I am qualified or not.
Technical bid means what? Whether you have an expertise, whether you have
all the papers are in order or not.
You have executed all the work, whether you are competent enough to execute those works for which this tender is floated. These are the technical bids.
Your Lordship, two documents will place. Page 36.
And then the question of rates will come.
My Lord, kindly look at page 36.
Yes.
Page
We are at 36, sir.
Qualified, first party qualified, second party qualified. 7-star, that is I am qualified.
Technical bid.
Technical bid.
No doubt.
Yes, my Lord, kindly bear with me.
Yes,
Advisory.
yes.
Technical evaluation, acceptance, rejection of a bid is buyer's prerogative and responsibility. JM has no role or control for this. If you feel that your bid is wrongly disqualified, immediately submit your challenge using representation such and such, rejection option available to participate such and such. Then, my Lord, this is what they say. The next page, my Lord. Financial evolution. 37.
Yeah.
That was on some days thereafter. That was on 25/2. Frontline ex-service bureau, my Lord. The other person, 330 quotes. My Lord. Page 37.
37.
Yes, Lord.
Yes.
List of sellers qualified financially. The heading is, my Lord. After the principal evaluation, there is a 2 sentence. Then the list of sellers qualified financially.
Yes. Correct.
Then, my Lord, frontline ex-service, 3 rupees 30 paisa.
Correct.
L1.
Yes.
Then, my Lord, myself, your Lordship, below, 7-star such and such, item category such and such, 3 rupees 89 L2.
Correct.
I question this in view of that, how could you make him L1 when the government of India circular at page 34 says that one has to give, has to minimum service charges is to be given on this. That is at page 34. He had not included that amount in the bid price.
You are saying that he cannot quote below the reserve price.
Below this price, at least he has to give 385.
That is the reserve price.
Yes, 385.
That is called the reserve price.
Reserve price. Below 385, it is not acceptable.
That's why he has.
So that became the, it is not that I.
So if that being the position, then you become the sole bidder. If it is the sole bidder, then in that event.
Let them say as much so that I can get a chance to dispel that, my Lord.
Is a clear mark.
That by automatically I am not out, my Lord. Ousted. If they had said that, I would have responded to the same, my Lord.
It is there in the page 37.
But
it is
just
there.
like
What else they can say?
Come to court and say just like that, your Lordship. They can't issue a letter in the rejection. They should have stated that in that what they uploaded in the website.
No question of issuing the letter or anything. It is a e-filing. The whatever things are actually uploaded in the system, they'll come to know all these things.
Mr. Sadangi, it is the GEM.
I agree with what your Lordship says, whatever he says. Now, your Lordship may look at page 13.
1.3.
If there is any deficiency, my Lord, in the technical bid, as he was saying, your Lordship, time allowed for technical clarification during technical evaluation. Page 13, my Lord, 1, 2, 3, 4, 5, 6, 7. 7th entry, your Lordship. My Lord finds it.
7th entry.
Time allowed for technical certificate clarifications.
2 days.
2 days.
During,
if there was any deficiency in my document, they could have given me the 2 days. If this is not acceptable, even in fact, earlier,
sir,
then,
sir, that is during technical evaluation.
No, that is something, your Lordship, 2 days.
Time allowed. Yes.
So that was always available. They could have asked me about the deficiency. if
That
any.
is with regard to technical evaluation.
Yes.
Sir, your last occasion, when Mr. Naik withdrew the writ petition, all these points he raised.
There
we took into consideration everything. Everything. And he then prayed that let me withdraw the writ petition. I will file a better writ petition. We got granted the liberty.
Better.
So all the grounds you are taking or arguments you are raising have already been taken care of.
My Lord, that is anyway, that is how your Lordship appreciates. I can't go beyond that.
If you have any better point and
No,
Mr. Naik, why have you not instructed the learned senior counsel properly?
No, he
That's what-
said, he said, my lord, he said that much, that this was the issue raised during argument. I said that they have to file an affidavit to that effect. So they have not given any answer to that. In fact, so how can you assume on that, my lord? Ground of rejection, nothing is there.
Did you ask for it?
Reason,
Did you ask for it?
I have given a
If you
representation,
ask
my
for
lord.
it, they will provide.
I have given a representation.
Did you ask for the detailed ground of rejection?
Sir, page 42.
Now,
Page 42, Lord. Para 11, my lord. This is my query, my lord, representation rather. Sir, despite our query and representation, you have not, my lord finds that paragraph 11.
Yes.
Sir, despite our query and representation, you have not supplied the reason for cancellation of the tender and have kept the matter in dark in order to wrongful gain and accommodate somebody else like existing manpower agencies, frontline such and such with malignant intention. That online tender is meant for transparency and violation of the same has its legal consequences in the matter of public tender such and such. My company was declared L1 and successful bidder kindly execute the work order of such and such. This has remained unresponded so far.
No. Did you ask for supply of that release material?
That is what paragraph? Huh?
No. You have intimated that you have not supplied. But did you ask for supply of?
In the earlier to that letter, my lord, we had asked. On 5/3/2025. You have not supplied for cancellation. That possibly will your lordship will accept that is the question asked from my side.
First tender has been floated, you participate. What is the?
What I'm submitting, your lordship, without prejudice to this pendency, I'll let this participate, your lordship could get it tested.
Why it will be kept pending?
That is your lordship prerogative, I can't say anything.
If you participate in the first tender, why it will be kept pending?
I am excluded from now itself, so there is no point in. Anyway, lordship will pass appropriate orders. I was praying that. Let it be kept pending. Let your lordship may allow me, notwithstanding pendency of this, let me participate in that.
We should not advise you. What is the last day?
Aji.
Today.
Sir, 11 this was your lordship listed before your lordship. We filed it yesterday, it was filed. Then while your lordship accommodated us today. So there could not be earlier to this.
No. I am not on that.
We understand.
We are not on that.
And unfortunately, on last 2 days of the last week, my lord was not there.
Yes, before 5.
That was the earlier petition, my lord.
So, taken adjournment. We will not keep it pending. If
let it get pending.
Unnecessary.
Tomorrow, ask. Tomorrow. You take instruction, my lord. That is what I am submitting. Without prejudice, I may be allowed to participate.
No. We will not allow.
Your lordship may call me tomorrow.
You may withdraw it to third time. We will not allow any liberty further because that liberty.
No, I know lordship's mind. And hostility showed from his side. No, it was for this reason, undisclosed reason. There's no reason. We have asked for something they have not provided. But to all these, my lord, let come tomorrow. We'll inform his client what he's going to do, so it will be easier for him also. Tomorrow is not feasible, some other day, my lord.
How it serve your purpose? Because the today is the last day for that tender. How it serve your purpose?
Even if it is pending, my lord, if I want to apply, I can apply. Still time is there.
Till 12.
Time is there. Even if it, my lord, pending also doesn't matter. Only that professional side of it.
Pending matters. Matters for us.
No, if tomorrow is not possible, some other day.
Pendency of the petition matters for us.
I'm not seeking for any indulgence on that. I'm not seeking anything. Now, I understand your lordship, what your lordship says. Simple adjournment.
As prayed for by Mr. Sadangi, learned senior advocate, put up this matter on 17th April 2025. Yes.
Item 29.
May I please your lordship? On behalf of Mr. R.K. Rautrai, his grandfather dies today. Kindly the matter may be taken up next week.
Thought instruction as to the shifting of 33 children in that ashram, your lordship. That will be taken.
You have already checked.
Please, lordship, that on 19th, they will conduct a drive with police protection.
Our Lord had directed us to file an application for condonation of delay on the last decision, as there was a mistake in filing the certified copy of the order during the review petition. We had by mistake filed the Xerox copy. Yes, the certified copy was filed also. Only the condonation.
Condonation application is filed.
It is filed this is the condonation filed application filed persons through the order directed.
Have you filed it? Filed.
Yes, ma'am. Certified copy was
What do you
filed.
have to say on the condonation?
The only thing is that
Where is the?
I sent it.
Which page? Where is the order of assignment?
Yes, at flag
X.
Flag X. Flag X. Double CJ and Carol.
No. Assignment to whom? Oh, he's a member. Yes. How many days delay?
2,336. And what had happened that
Explanation.
while we filed the review petition, by mistake we had filed a Xerox copy of the certified copy. Thereafter, we filed the
While within the time?
yes, within the time, within 30 days. We had filed the review.
Along with the photocopy.
Yes, we had by mistake filed we had received the certified copy, but by mistake we had filed the Xerox copy. Though afterwards we had supplied the original, but we forgot to file this application and it was never pointed out. Matter was entertained, notices were issued, proceedings went on. Only on the last occasion it was pointed out that the application.
It's a technical delay. It's not real delay because the application was within time.
this one. They admit that they inadvertently filed it. Xerox.
What is the IA number?
IA number 134 of 2020.
134 of?
2025.
Okay. IA number 134 of 2025. This is an application for condonation of delay of 2,336 days in filing the review petition, as pointed out by SR. Learned counsel for the petitioner, review petitioner, submits that though the review petition was filed in time, but due to delay in filing the certified copy of the order sought to be reviewed, comma, delay occurred in filing the staff reporter has pointed out the delay, pointed out the aforesaid, pointed out a huge delay, huge delay. In fact, although the certified copy of the order sought to be reviewed was obtained by the petitioner, review petitioner, but it could not be filed inadvertently. Thus, the delay in filing the review petition should be condoned. Mr. Dark learned counsel, learned additional standing counsel submits that in fact the review petition was filed in time, but due to delay in filing the certified copy of the order sought to be reviewed, comma, the staff reporter has pointed out the delay as aforesaid. Considering the submission made by learned counsel for the parties and if more particularly to the fact that the review petition was filed in time and the delay occurred due to delay in filing the certified copy of the order sought to be reviewed, comma, we are inclined to condone the delay in filing the review petition. Accordingly, delay of 2,336 days in filing the review petition is condoned. IA is disposed of. Yes. Then under the heading of review petition will be listed on 7th May 2025.
Item number 31.
On behalf of Mr. Das, my lord, finally taken on next week.
As what is your good name, sir?
N. Jena, Niranjan Jena. Niranjan Jena.
Mr. Jena, learned counsel for the learned counsel, prays for an adjournment on behalf of Mr. Das, learned counsel for the petitioner. Put up on 6th May 2025.
Item 32.
This is the direction for compliance with 13 billion idea. There is the area we have already paid and filed the compliance affidavit. Copy has also been served on 27 on the other side.
After the I am appealing for the opposite parties.
And the amount has been
from bonus
been credited to the account of the.
Oh, you are appearing for the collector from
Collect a man.
You are.
Yes, for manager.
And you are the sole respondent. Yes, Lordship. So you have already paid.
State.
Only paid up to January.
Workman for workman, Mr. Sahu was appearing, he is not there.
I am for the workman, Lordships. Oh no, he is appearing for the workman.
Mr. Das is appealing for the workman.
Yes, Lordships.
We have already deposited the dues in his account and filed the compliance affidavit. Copy has been served on 27.
What is your instruction?
Lordship, the petition has paid up to January 2025. But there are
the affidavit that from January we have paid, February and up to the April end we are processing, we will pay in the end of the April.
Yes.
So by end of the April you will get it.
Yes, Lordship.
3 months you will get.
It is submitted by Mr. Kara, learned government advocate, that the amount, the amount calculated under section 17B.
17B word.
17B of the Industrial Dispute Act 1947, calculated up to January 2025, has already been deposited in the account of the workman. Payment of dues under 17B from February 2025 till April 2025 will be paid by end of April 2025. So, Mr. Das, learned counsel for the workmen, submits that that the workman has already received dues under section 17B up to January 2025. Hence, this court adjourns the matter to be listed on
8th May. 8th May.
8th May 2025. On which date learned state council shall appraise up-to-date status of payment of dues under section 17B to the workmen.
Item note 33.
Your Lordship, I need some more time to file the affidavit in terms of the last order, Your Lordship.
What was the last order?
19/3/2025.
9 affidavits have been filed by the opposite parties from the various district judges. Each affidavit I have to reply.
Oh, this is the regarding court office of the court manager.
Court manager. I need some more time. They are placed at very. And then also I'll file the detailed affidavit to each, reply to all the affidavits that have been filed.
Yes. Mr. Mohanty, learned counsel for the petitioner, prays for further adjournment to file affidavit in terms of order dated 19/3/2025. 19/3/2025. Let the affidavit be filed within
1 week.
Within 1 week, as undertaken, serving copy thereof on learned state council to enable them to respond to the same. Put up on
30th April. Sorry. 14th May.
14th May 2025.
Item 34.
Maybe pardon, there was an interim order. In item 33 as well.
Certified copy.
34.
Donation of delay. What is the delay, Mr. Das?
Item 34, there is a delay of 390 days.
I may be pardon your lordship.
Yes,
Item
yes.
33, there
Oh,
are three.
sorry.
I'm so
If you order dated for answer, sir, continue till next week.
So grateful.
34.
What is the delay of 390 days?
390 days.
Notice has to go on the question of revelation.
Issue notice, IA number
403.
4033 of 2024. Issue notice to the opposite party.
I am appealing, but this is all respondent. So,
All the respondents,
sole respondent.
sole respondent.
Yeah.
Sir,
Sole
have you filed your Vokalatnama, Mr. Pati?
Sir, today.
Today.
Please. And sir, copy on.
Mr. Pati and counsel for the learned counsel submits that he has instructions to appear on behalf of the contesting respondent. Sir. He also files Vokalatnama on behalf of the respondent number 1 in court today. A copy of the IA be sought on Mr. Patil learned counsel for the respondent number 1 by tomorrow as undertaken by Mr. Das learned counsel for the appellant. Learned additional government advocate. Step. Put upon, yes, Mr. Pati, only 300 odd days. I will take instruction on the limitation. Huh?
He wants to file the objection.
Okay. All right.
Because my lord, the
All right, Mr. Pati.
all these portions said they are getting the order has been passed by the learned tribunal to grant directed to grant the benefit of grade of 6,600.
Consider you want to you file objection, we'll consider. Save your energy. But
they give the benefit up to 3 days.
Mr. Patil and counsel for the respondent number 1 for the praise, further submit, further praise, sir, submits that he may be required to file objection after receiving the copy of the IA. So, put up this matter
5th May.
5th May 2025. Objection to the IA, if any, shall be filed in the meantime, positively serving copy thereof on learned counsel for the appellant, learned state counsel for the appellant.
Item 35.
There is a delay of 172 days. What is this matter? So for certified is concerned, copy is concerned, we have already filed.
You have already filed a certified copy.
Certified copy we have already filed on 11/4/2005. 25.
171 days. Private. Who is appearing for the respondent?
I am appearing for the respondent number 1, my lord.
Yeah.
Who is 2?
Who is 2?
This 2 is public administration and defense.
Sorry, my
Chief Secretary.
Certified copy are filed in 1 week.
Oh. Only one is the contesting respondent.
Only sole respondent.
Sole respondent.
They have added by writing in pencil. Public
I see.
Rajesh Kumar Pandey.
You are appearing for Rajesh Kumar Pandey.
So he's the sole respondent.
He is the sole respondent. Have you filed your Vokalatnama?
Yes.
Yes.
My name is appearing.
Okay.
My lord, the cause of action for filing of this writ appeal has already taken care of by the state. They have come up with the next notification.
Recent notification, my lord, has come that so far appointment of Rehabilitation 1990 and 2020 is concerned,
there is an amendment and rule 6 has been changed saying that to the previous 90 rules are considered, those who have died before 90 that will apply
90 rule
and
will
220 will not apply to the pending cases. So government has come forward with that amendment.
This. Yes, my lord, in view of this notification, this.
Cause of action for filing writ appeal does not survive.
Yes.
Yes, Mr. Karan, is it so?
That is the question.
Yes, ma'am.
Then what to do? What was the direction?
What was the direction in the impugned order? To consider your case under 1990 rules.
Yes, my lord.
Yes, ma'am.
So now the notification has come, your case will be considered under 1990 rules.
Yes. This
Let it come.
is infraction.
Let it come next week, I will get. Because there is an instruction to government to say that all the pending cases 90, that was to dispose of 90 rule, who have died before 90. Rule 74. And
Mr. Kara, that is not the case. If a survivor of a government employee or a dependent of a government employee applies under 1990 rules and that is pending, then that will be considered under 1990
rules.
So the crux is whether the applicant has made, the repetition had made application under 1990 rules or 2000 subsequent.
90 rules.
Huh?
90 rules.
90 rules. Then
90 rule he applied because that was considered. That's why when 20 rules came, it said that all were pending cases, so will guide by 20.
But
by recent amendment, they have said that it will consider
90 rules.
Yes.
So why it will come next week? What is
your lordship may dispose of?
Your lordship can dispose of, saying that in terms of this amendment of the 2020 rules.
no cause of action for filing of the writ appeal does not survive.
Doesn't survive. His case will be reconsidered once again in terms of the.
Will consider in view of the.
How can it be reconsidered? Because the direction is.
Direction is there.
Since
There
this
is
is a
already a
written.
direction which says that joining letter will be issued and the salary and he will be discharging the duties and will be paid the remuneration and salary. How can we dispense with?
Please come to para 11.
It says that the writ petition is allowed. The opposite parties are directed to accept the joining report of the petitioner within a period of 6 months, 6 weeks from the date of communication of the certified copy. The petitioner be allowed to discharge his duty. Moreover, it is needless to mention here that the petitioner shall be paid his salary and remuneration as is due and admissible to him. What more consideration?
What more consideration?
Maintain that order may be maintained.
This is the.
So,
we are condoning the delay and we are taking up the main matter also.
Yes, ma'am.
With the consent of the councils and then in view of this, we are disposing.
Yes, ma'am.
IA number 4850 of 2024. This is an application for condonation of delay of how many days?
172 days.
171 days in filing the writ appeal, as pointed out by sir. Upon hearing learned counsel for the parties, we are inclined to condone the delay in filing the writ appeal. Accordingly, delay of 171 days in filing the writ appeal is condoned. I is disposed of it accordingly. Step. Writ appeal that. On consent of learned counsel for the parties, the writ appeal is taken up for consideration. Step. The writ appeal has been filed. The intra-court appeal has been filed, asserting the judgment, order dated 14/12/2023, passed by the single bench in WPC number 28860 of 2022 with the following direction. Para 11, with 4 para 11. Sir, the crux of the matter in the writ appeal is the crux of the matter in the writ appeal is with regard to applicability of the applicability of Orissa Civil Service Rehabilitation Assistance within bracket 10 rules 1990 to the applicability of rehabilitation assistance rules 2020 to the case of the appellant. The issue involved in this writ application is as to whether Orissa Civil Service Rehabilitation Assistance Rules of 1990 or 2020 would be applicable to the case of the applicant, to the respondent. The single bench holding that the rehabilitation assistant, Orissa Civil Service Rehabilitation Assistant Rules 1990 would be applicable to the case of the respondent within bracket writ petitioner, allowed the writ petition. Sir, Mr. Kara, government advocate, submits that the issue is no more recently in view of the amendment to the aforesaid rules. In view of the enactment of amendment of now in view of coming into force of Orissa Civil Service Rehabilitation Assistance Amendment Rules 2025. In view of the aforesaid amendment to the rules to the Orissa Civil Service Amendment Civil Service Rehabilitation Assistance Rules 2020, cause of action for prosecuting the writ appeal does not survive. Mr. Lal, honored counsel for the respondent number 1, also does not have any objection to this. In view of the above, the writ appeal is disposed of as infructuous with an observation with a direction that with an observation that the direction given in order dated 14/12/2023 in WPC number 28860 of 2022 shall be complied with within a expeditious. Sir.
$36.
The order dated 24/3/2025 has been directed me to file the press request for issuance of notice to officer of female. In fact, my lord, twice notice, my lord, sent return answer. And the base, my lord, correct address could not be collected. I pray, my lord, mercy times direct for paper publication.
Substituted service, you have to make an application.
I shall make an application. Yes.
Make an application saying that they are awarding that substituted service.
I shall file my diary.
Mr. Smile, honored counsel for the petitioner, submits that in spite of several attempts, notice on opposite part number 3 could not be solved as they are avoiding to receive notice. He therefore prays for a short adjournment to file an application to take out notice take out substituted notice. Step. Let the application be filed within a period of 1 week. 1 week hence. Put upon
30th April.
30th April 2025.
Sub-item also same.
Sub-item also same order.
Item number 37.
37, my lord. Certified copy of the order has already been filed. So that interim application becomes incomplete.
Condonation of delay.
Condonation of delay.
Oh,
that I
rejoinder counter has been filed by them.
I have not been served a copy of that.
Objection.
Counter affidavit.
That was the direction passed for.
Yes, that was the direction. That was the
On 28/3, sir.
6/3/2025.
28/3. On 28/3, there was a direction, let the learned counsel for the respondent serve a copy of the objection.
Yes,
to
that was
the
the direction.
Learned counsel for the appellant. Where is that? Why you did not serve?
Next to you. Next to you.
Then we are allowing the condonation application. If you think that nothing is to be done, then what?
Next to you.
Why so casual approach? Give him a copy. Do you have extra copy?
Do you have extra copy? Give it just now.
Yes, ma'am.
Copy of the objection is served on Mr. Das Leonard, additional government advocate in court today. Are you ready or we'll take it up from?
You want to file rejoinder?
May not be required.
All right. All right. As paid for by Mr. Das Leonard, additional government advocate, put up on 24th April 2025.
Item 38.
38 is same, ma'am.
Same.
Yes, ma'am.
You're appearing.
My lord. That's the number.
Thank you, sir. Please give him a copy.
Tomorrow I will send you.
Whether you have filed objection?
Oh my.
Then tomorrow what?
Both of you said same, so I thought the same order is passed for service of the objection.
Yes, it's same.
Oh, really?
Next to you. Next to you.
Same day. Yes. What is your good name?
N. Janam.
Sorry. Mr. Janal and counsel for the respondent prays for a further adjournment to file objection to the objection. Step. Let the objection be filed within a period of 1 week, serving copy thereof on learned counsel for the learned state council. Step. Put up on 24th April 2025.
Item 39.
May I please? This interactive appeal has been filed. Challenge the order dated 24th September 2024 of not deducting the commuted pension amount. The appellant here is the banks. And they are also in that common cause matter by the apex court.
What is the interlocutory order?
Yes, sir.
The matter is still pending, the rejection.
Yes, your lordship. Interlocutory order is not to deduct the commuted pension. I am relying upon the Supreme Court judgment in the common cause court case where it has been categorically held that there should not be any judicial interference as far as
2022.
And more or less what has happened, your lordship, they have filed several similar matters and the coordinate bench of this honorable court has passed these interim orders and thereafter, without following Article 226 clause 3, they have filed contempt applications And contempt is being pursued against the bank. That is the only difficulty.
Who is appearing for the respondent? Junior officer?
39. UCO Bank. UCO Bank.
No, the UCO bank.
Yes, sir.
Why the Union of India is shown as a.
Yes, because they were made parties by the writ petitioners.
No. Who has filed the petition?
The respondents have filed, we have filed the writ appeal. The bank has filed the writ appeal.
Oh, they have been treated.
Yes, sir.
There is a delay.
There is a delay, 120 days.
Notice is to be given. His right has accrued. You have started arguing on a merit, taking a plea of demur.
Mr.
So we were impressed by the plea of demur.
IA number 1239 of 2025 issue notice to only sole respondent.
Yes, sir. The writ petition respondent.
Writ petition respondent by registered post with stroke speed post with AD, requisites for which shall be filed by tomorrow. By 17th April 2025 as undertaken. Put up this matter on 14th May 2025 along with tracking report of the postal department.
Item 40.
DPU.
Certified copy of already you have filed on 7/3. There has been a delay of.
This is IA. Which one? 1276 or 75?
212
1276.
1276. 220 days delay. That's stamp. It's the stamp or photo. Yeah. Yes. Make it bold so that we can.
Your Lordship.
Yes, sir.
Your Lordship, the respondent is going to retire this month, man. The honorable one order passed by Honorable Justice B.P. Satpathy on 2/7/2024. Well, can you see page 16, para 7.3?
So you are appearing for the respondent.
Respondent.
So do you have anything to say on the condonation of delay? Today it has come for condonation of delay.
Yes, my lord.
There is a delay of 220 days. What do you say on delay?
I have already filed a first contempt. That is the contempt number 7.
What first contempt? Contempt. What first contempt? So whatever. What is your submission on his prayer for condonation of delay?
Delay. No, petition is going to retire this month, Your Lordship.
Do you have any objection?
Objection, I am.
Then file your objection so that they can respond to it.
Since my landlord is already appeared, I am.
Oh, your notices are not.
Received any
Okay.
Let
a copy of the 1276 of 2025. This is an application for condonation of delay of 220 days in filing the 212 days in filing the writ appeal. Let a copy of the IA be served on learned counsel for the respondent. Do you have an extra copy?
Just now I don't have.
By tomorrow? By tomorrow as undertaken by Mr. Das, learned additional government advocate. Next. April 2025. Objection, if any, shall be filed by the respondent in the meantime, serving copy thereof on learned counsel for the appellant. Yes.
Item number 41.
Lordship, on last occasion, your Lordship has allowed my amendment application by order dated 11th April, your Lordship. And the amended application, the consolidated writ petition has already been filed, your Lordship, and copy has been served. As I find in the noting that there is some discrepancy with the annexure, your Lordship, I will make sure that the same is corrected and placed on record, your Lordship. Let the matter come on 24th,
What
your Lordship.
discrepancy, madam? What discrepancy?
Last time, your Lordship had allowed the amendment. The letter of award which was issued, they wanted to amend it, repeat a record. The amendment is allowed, but they have not brought the annexure on record, the letter of award.
It is on record, in fact, your
The
Lordship.
tender has already, L1 is there, it has been awarded and he is doing the work. They wanted to challenge that, they did the amendment. Amendment is allowed, the Lordship allowed the amendment and allowed to file the consolidated application. They filed the consolidated application, but the annexure has not.
They did not annex that award.
That letter of award.
They wanted to annex it. It is already there in the file.
It is already there in the amendment application. It only has to be brought along with the consolidated petition.
It is a ministerial error.
I pray your Lordship next week, Thursday, your Lordship.
Mrs. Sahul and counsel for the petitioner submits that she will make good the deficiency in the consolidated writ petition by next week.
By next
Within
week.
7 days. Within 7 days. Put up on 24th April 2025.
Obliged.
Item 42.
If we get to bind on the matter. If we get have not been filed, so it may kindly take us 1 in time may be granted violation.
More than 1 month has elapsed. Mr. Mistral and you have an interim order in your favor.
Subject to the not that they.
It is that requisition of vehicle.
Yes, not supplies to that extent. Different regions to be supplied.
Different districts.
Yes, madam.
Yes.
1 in time.
Mr. Mistral and counsel for the petitioner submits that inadvertently order dated 10/3/2025 could not be complied with by filing requisites. He undertakes to file requisites within 1 week.
Not supplies.
Within 1 week as undertaken. 1 week. Step. Put upon. If the requisites are filed within within 1 week, notices if the requisites are filed, notices shall be issued forthwith, fixing a short returnable date. Put upon
14th May.
14th May 2025.
For admission, item 43.
My lord, in that issue of
Matter realistic.
My lord, in that case, last time your lordship asked the additional commissioner was Bishi to know within the time schedule within which the drain work will be completed. I requested him to send me time schedule. I have passed on to your lordship. That saying that by
Somebody is on a virtual mode. Who are they?
yes, yes.
You can monitor it from there.
Correct. Yes, monitoring.
Yes, you can see that somebody is appearing on a virtual mode, sir.
There, commissioners, additional city engineer, they are there, madam.
Oh.
I will be.
So they have given a timeline within which they can do it. They say that within 10 days, minimum 10 days is required for a technical sanction. And then say by 25th of this month, they will immediately float because we are already on 16th. So they wanted within 9 days, they will float the tender. And the process will be completed by 15th of May. And then they say that everything will be done and the work will start immediately thereafter. And main thing is when it can come to an end.
They have also indicated regarding completion of the work, last paragraph. April 26. The work is likely to be completed by end of April 26, 2027. That last paragraph.
As far as the building is concerned,
my limited prayer before your lordship is that let them expedite the work and work should be completed before.
That is what they always take on a very higher side they take it, but we will definitely monitor it, the progress of those works at a interval, so that at least the process the process is continuing. Otherwise, that will.
Only prayer, my lord, prior to the timeline indicated in this report, maybe
as far as the building is concerned also.
Has to be done.
As per the building is concerned also, they stated that it will be completed by March 2022. They will take another 3.5 years. In earlier occasion, they also stated without drainage system, it will not be operated. How without drainage system it will be operated, and without drainage, how they construct the G+6 building, and they asked sanction in 2024.
No, sir. It is the building which is constructed first, and then the moment it is completed, then the drainage system, the line, the sewerage line has to be drawn and connected with the main sewerage line. This is the outer exercise. And we do not know here that what is the distance from that building, because it has a sewerage system. There is no doubt about it. But you have to connect it with the main sewerage.
Now they are draining out by digging a pit, my lord, they are storing there, or by pumping it to the old drain. This is the system now going on. Today I ascertained from the city engineer.
And how far the main old drain is?
About 300 feet to connect.
Why it would require so much of time? Because it should not require so much of time.
14 years has already been passed.
Your lordship, talk to them.
May I
who is appearing? Is a chief engineer?
No, city engineer is there, my lord.
City engineer. Sir, why you are taking such a longer time?
Namaskar, sir. Additional commissioner is here, sir. City engineer is on tour, sir.
Why such much? You have to simply connect the sewerage system. That's all.
Sir, city engineer has made a detailed estimation and has tentatively fixed the completion date, sir.
Why you are taking a longer? When you can start in the month of June, then practically 9 months it should not take. It is merely a joining of the sewerage line, nothing more than that.
Entire colony
he says 300 meters.
My entire colony drain needs to be revamped, man. So far, the first phase work is concerned, from the main building, new building to the existing drain, they may make the construction immediately so that they will take.
That's why I was just thinking it does not take much time because it's a connection. Anyhow, we will be monitoring it on that basis. We are definitely looking at it.
And not 300 meter, my lord, 300 feet, my lord. Learned senior submitted 300 feet, my lord.
You say, what is Mr. Budhia? You are
300 feet is
are
not
there in the
that
field.
big. 300 feet is not that big. Anyhow,
But may I pray, madam? Yes. Let a technical team be visited the.
sir, they are the technical, they are the city engineers. What more? You have to rely upon somebody. Only thing is the work has to be done. This is what we are ensuring that the work is done.
Progress of the work.
Definitely at the periodicals, we will this matter to oversee that what is that.
Just the development.
That is that. And the development of the work should be monitored by this number.
Definitely.
Progress will be monitored matter that is.
Definitely, sir. If you have taken up the matter, means we will monitor the progress.
No, we are confident. That's why we are listing this matter at a very short.
Yes, ma'am.
I see.
Yes,
So this is the reason for that.
yes, ma'am. Your Lordship has given a sufficient opportunity. By now, they have already gone 14 years. Only for the interference of this Honorable Court, the work is progress.
Otherwise, it would not complete.
Your Lordship will fix the date to some date after 15th May, my lord.
Yes, yes. On the earlier officer, that is 9/4/2025. The Additional Commissioner, Cuttack Municipal Corporation, who was virtually present, informed the court that the process of tender has already been initiated and likely to be published within a short interval. It was further indicated that the Cuttack Municipal Corporation has taken a burden for execution of other works, including the drainage system, so that the building already constructed can be made operation, can be made functional. However, the matter was adjourned as we wanted to know the timeline within which such work would be completed. Today, when the matter is listed, the city engineer, the commissioner, Cuttack Municipal Corporation forwarded the factual report of the city engineer, indicating that the detailed estimate is being prepared for construction of the drain, which would require at least 10 days to get the technical sanction. It is further indicated that after getting the technical sanction, tender will be floated by 25th of this month, and such process will be completed by 15th May 2025 by following the due codal procedure. What is this codal?
Code, what? PWD code is there. How the work is.
The city engineer the factual report further revealed that the work will be started from 1st June 2025 and may take 10 to 12 months to complete it. The question of the high-rise building has already at the verge of completion, but the same cannot be operationalized because of the lack of drainage system. So, we are conscious that the beneficiary of the health services are deprived of availing such facilities availing the health facilities. And therefore, the corporation must undertake the responsibility with some alacrity so that the work, that is the construction of a drain, is expedited and completed within the minimum time. Subject, however, that the quality of the construction should be maintained and or ensured. So, let this matter be listed in the first week of June 2025, when the council appearing for the corporation shall inform the progress having made as indicated in the said factual report.
Holiday, my lord. I pray.
Immediately upon the reopening of this form. So you say that you will start from 1st of June. So we are opening it immediately after that. So that's
See date 17th, 18th, 19th or 20th as your lordship pleases.
Lord, I may be pardoned to mention.
Lordship, I am pardoned to mention, I am in virtual lordship. I have mentioned item 83.
The batch of cases where interim orders were passed and they were till yesterday. So here in our system is that you will be listed on so and so interim order. I was only requesting if your lordship could extend the interim order till the next.
Who is appealing for the other side?
State.
Yes,
Interim order and let them file their counter so that the matter can be disposed.
In 2 cases, we have filed counters. We will file counters in other cases also connected.
Just give those, and the taken out of dirt on the mentioning of the council for the appellant or the petition.
Lordship, I may be pardoned to mention.
The interim order passed in the instant case, it was operating
All the cases,
yesterday.
all the batch of cases.
Also operated till yesterday. So since the matter could not be taken up it could not be taken up yesterday, and because of the paucity of time, even today, let the interim order passed earlier be extended till the next date of district. The respondent, the opposite party is directed to file some counter affidavit.
So both union and state both have to file.
Opposite parties.
Parties. Your lordship will say.
Within what?
4 weeks time.
3 weeks or 2 weeks?
3 weeks.
Within 3 weeks from date? This is the matter.
14th May.
Grateful.
Item 110, my lord. I'll get out tomorrow, my lord. They're testing the.
Do one thing, don't list any other matter except this. Or if you want to list, then this matter should be first.
Yes,
Lordship, item 86, I have mentioned your lordship.
We have reached up to 56. Yes, ma'am. So the first matter tomorrow, which will be take up, will be 57.
Lordship,
Lordship,
Lordship.
44 will be the first matter. And all the matters are fixed for the day in board.
Lordship, item 86 is calling, your lordship is calling tomorrow, item 86, lordship.
Yes, sir.
And that's not something to be made if your lordship permits only. Item number 43, my lord. Date of completion has been indicated in the.
That is there. We have taken care. Mr. Das, we have taken care.